Hey, John, is my audio and video okay?
Yes, sir. Audio, video sound good. You are good to go.
Thank you.
Sure. Good morning, Commissioner Hughes.
Morning, John. How's it sound?
Audio sounds good and video looks good. You are good to go, sir.
Thanks.
Sure. Last call for audio video check. If you want to do an audio video check, please turn on your video and I'll call them.
All right, Kim Mitchell, just checking in with you. Give me the signal that you are ready to go.
Yes, ma'am.
Thank you. All right, good morning, everyone. Let's come to order and go on the record, please. I'm Charlotte Mitchell, Chair of the Utilities Commission, and with me via remote connection this morning are Commissioners Tanola D. Brown-Bland. Please announce your presence.
Good morning.
Commissioner Lyons Gray.
Good morning.
Commissioner Daniel Clodfelter.
Yes, good morning.
Commissioner Kimberly Duffley.
Good morning.
Commissioner Jeffrey Hughes.
Good morning.
And Commissioner Floyd McKissick.
Good morning.
The commission now calls for hearing docket numbers E-2 sub 1262 and E-7 sub 1243 in the matter of joint petition of Duke Energy Carolinas LLC and Duke Energy Progress LLC for issuance of storm recovery financing orders. On October 26, 2020, Duke Energy Carolinas and Duke Energy Progress, to which I will refer to as the companies, filed a joint petition for financing orders pursuant to North Carolina General Statute 62-172, seeking authority from the commission to finance the storm recovery costs incurred by each company due to Hurricanes Florence, Michael, and Dorian, and Winter Storm Diego. The petition was supported by testimony from Thomas J. Heath, Jr., Charles N. Atkins II, Melissa Abernathy, Jonathan Bird, and Shanna W. Angers. On November 6, 2020, the commission issued an order scheduling the hearing, requiring filing of testimony and establishing discovery guidelines. The scheduling order, among other things, set this matter for hearing on this date and at this time to be heard remotely using video conference technology in light of the ongoing COVID-19 pandemic. The participation of the public staff in this proceeding is authorized pursuant to North Carolina General Statute, Section 6215. And additionally, petitions to intervene in the proceeding were filed by Carolina Industrial Group for Fair Utility Rates 2 and the Carolina Industrial Group for Fair Utility Rates 3, which petitions were granted by order of this commission. Each of these parties to the proceeding has consented, as evidenced by filing made in the dockets, to conducting this hearing remotely using video conference technology. On December 21st, 2020, the public staff filed the testimony of Calvin C. Craig, as well as the testimony and exhibits of witnesses Joseph Fischera, William Moore, Barry Abramson, Stephen Heller, Rebecca Klein, Brian Mayer, Hyman Schoenblum, and Paul Sutherland on behalf of the public staff. On December 22nd, 2020, the public staff filed the joint testimony and exhibits of Michael Manus and Michelle Boswell. On January 6th, 2021, the public staff filed corrections to the testimonies of witnesses Sutherland, Heller, Fischera, Manus, and Boswell. On January 11th, 2021, the companies filed the rebuttal testimony and exhibits of Thomas Heath, Charles Atkins, and Melissa Abernathy. On January 13th, 2021, the public staff filed a revised version of the public staff direct testimony corrections, which had been previously filed on January 6th to correct witness Heller correction item 2 and witness Fischera correction item 4, as well as the complete corrected testimonies of public staff witnesses Sutherland, Heller, Fischera, Manus, and Boswell. On January 25th, 2021, the companies filed a notice of billing compliance procedure and the affidavit and supporting exhibits of Jonathan Bird. On that same day, the companies also filed an errata to Jonathan Bird's direct testimony. On January 27th, the companies and the public staff filed a stipulation of agreement and partial settlement in this proceeding. Also on January 27th, the companies filed a motion requesting a temporary waiver of the statutory 135-day time frame to receive a final order on the company's joint petition in this proceeding, and requesting that the 135-day time frame be extended by 30 days through and including April 9th, 2021. The companies maintain that the 30-day extension will grant the commission time to rule on the prudency of the company's storm recovery costs and the company's ongoing respective general rate cases, which determination is required prior to the companies being able to proceed with organization. Finally, and also on January 27th, 2021, the companies and the public staff filed a joint motion to excuse witnesses Bird, Andrews, and Craig from appearing at the hearing today. That brings us to today. In compliance with the requirement of the State Government Ethics Act, I remind all members of the Commission of their responsibility to avoid conflicts of interest and inquire at this time whether any member of the Commission has a conflict of interest with respect to matters coming before us this morning. All right, the record will reflect that no one indicated a conflict in this matter. There appearing to be no conflicts, we will move forward, and I now call on council to announce their appearances, beginning with the companies.
Good morning, Chair Mitchell, members of the Commission. My name is Kamal Robinson, Associate General Counsel on behalf of Duke Energy Carolinas and Duke Energy Progress. Also appearing with me from Duke Energy is Mr. Bo Summers. Additionally, we have appearing with us from the law firm of McGuire Woods, Jim Jeffries, and Kristen Athens. All of our attorneys have filed our appearance sheets and have provided them to the court reporter via email. Thank you.
All right, good morning, Mr. Robinson, Mr. Summers, Mr. Jeffries, and Ms. Athens. All right, Sigfer.
Good morning. This is Christina Kress with the law firm of Bailey and Dixon, appearing on behalf of SIGFR 2 and 3.
Good morning, Ms. Kress. All right, and the public staff.
Good morning, Chair Mitchell, Commissioners. Bill Grantmeyer for the Using and Consuming Public, along with Zeke Creech, Using and Consuming Public. Thank you.
All right, good morning, Mr. Grantmeyer and Mr. Creech. All right, before we will begin, I will address the open motions. The Commission has no questions for witnesses Bird, Andrews, and Craig, and therefore the motion to excuse these witnesses is granted. At the appropriate time, Council, I'll entertain motions to admit the pre-filed testimonies and exhibits of these witnesses into evidence. Next, turning to the company's motion for a waiver of the 135-day time frame, want to hear from the public staff, see if the public staff has a response to this motion. Mr. Grantmeyer, you're okay.
We do not oppose it.
Well, Madam Chair, just to clarify, you're speaking of of which, I'm sorry?
Mr. Creech, just please announce your presence for purposes of our court reporter. I asked if the public staff has a response to the company's motion for a waiver of the 135-day timeframe.
Madam Chair, I'd like to add to my colleague Bill Grantmire's comments. This is Zeke Creech with the public staff. We are actually still reviewing that and would like the opportunity to file some comments with the commission on that particular point.
So, Mr. Creech, just so I'm clear, the public staff intends to file a response to the company's motion?
I believe that we will.
All right.
Yes,
well, I will refrain from holding on the motion until I receive the comments of the public staff. Do you anticipate those comments will be filed this morning or later today?
I do not know at this time. Let me consult with Mr. Grantmire and we will let you know.
Okay.
Thank you so much.
All right. Okay. One last point, housekeeping matter before I turn to council to see if there are any other preliminary matters we need to address before getting into the testimony is scheduled for the day. We will obviously we began at 10 o'clock. We'll go until about 12 o'clock, at which point we'll recess for lunch till 1:30. We will resume at 1:30 and we will go until 5 o'clock this afternoon, and we will take a break somewhere in there for our court reporter. All right. With that, any other preliminary matters before we begin?
Chair Mitchell, this is Kamal Robinson. I have a few.
All right. Please proceed, Mr. Robinson.
Thank you. So Chair Mitchell, at this time, we ask that the company's joint petition, exhibits, and appendices be entered into the DEC and DEP records.
All right, Mr. Robinson, hearing no objection to your motion, it is allowed.
Thank you. Chair Mitchell, the next one I have on January 25th, 2021, as you indicated, the companies did file a letter notifying the Commission of an alternative billing compliance procedure for DEP with the accompanying affidavit of Jonathan L. Bird and supporting exhibits. At this time, the companies request that the letter, affidavit, and exhibits be entered into the record.
All right, Mr. Robinson, hearing no objection, your motion is allowed.
Thank you, Chair Mitchell. My next one, as you also indicated, on January 27th, 2021, the companies and the public staff entered into an agreement and stipulation of partial settlement. At this time, I request that the agreement and stipulation of partial settlement be moved into the record.
All right, Mr. Robinson, hearing no objection, that motion is allowed as well.
Okay. Thank you, Chair Mitchell. Question with regards to the testimony, pre-file testimony of Jonathan Bird and Shayna Angers. Chair Mitchell, I'm happy to move those into the record now, or if you prefer that to be done at a later time, you let me know.
Well, thank you, Mr. Robinson, for the question. What I would like is, just for purposes of clarity of the record, have the company introduce the testimony of its witnesses during the point in the hearing at which the company witnesses are testifying, and then we'll hold the public staff's testimony until the point in the hearing when the public staff witnesses are testifying. So unless there are any other preliminary matters that we need to address, we can move forward. And Mr. Robinson, you can move to introduce the testimony of the witnesses who've been excused.
Thank you, Chair Mitchell.
Okay. Any other preliminary matters, council?
Just one last FYI, Chair Mitchell. So some of our attorneys and witnesses will be receiving some help from our assistants to just get them set up in the locate exhibits to minimize disruption to the flow of the hearing. So I just wanted to alert the commission and of the intended practice, as well as the parties, and just ensure that to the commission and the parties that the role is an administrative one purely. Okay,
understood. And thank you for the notice. And just one last reminder from me, we are all well versed at functioning remotely these days, but just remember, keep your mics on mute unless you are speaking, just to minimize background noise and to allow our court reporter to hear everything that is being said. All right, any other preliminary matters?
Nothing from the companies, Chair Mitchell.
Okay. All right, hearing none, the case is with you, Mr. Robinson.
Thank you, Chair Mitchell. Our first witness is Mr. Tom Heath, and he will be presented by Mr. Jeffries. Thank you.
All right, Mr. Heath. There you we are. Mr. Jeffries, let me see if I can find Mr. Heath. There he is. All right, Mr. Heath, would you raise your right hand, please? Do you affirm that the testimony you are about to give will be the whole truth and nothing but the truth?
Yes.
Excuse me. This is Kim Mitchell, court reporter. Is anybody else getting feedback on their end?
Yeah.
I'm having a little trouble here in the chair, but everybody else seems to be fine, but she's breaking up just a little bit.
And this is Christina Kress with Sigbert. I too am having trouble hearing the chair.
Okay, let me adjust my settings. All right, is this any better?
Yes.
Okay. All right. All right, Mr. Jeffries, you may proceed.
Thank you, Chair Mitchell. Mr. Heath, could you please state your name and business address for the record, please?
Sure. It's Thomas Heath, and my business address is 550 South Tryon Street, Charlotte, North Carolina, 28202.
And where do you work, Mr. Heath?
I work for Duke Energy Business Services, an affiliate service company of Duke Energy Carolinas and Duke Energy Progress.
And what's your position with Duke Energy Business Services?
I am employed as a structured finance director in our Treasury Department.
Thank you. Are you the same Tom Heath that pre-filed direct testimony in this proceeding on October 26, 2020, consisting of 37 pages, and Heath Exhibits 1 and 2A through 2F?
Yes, I am.
And Mr. Heath, was that testimony prepared by you, and were those exhibits prepared by you or under your direction?
Yes, they were.
Do you have any corrections to your pre-filed direct testimony or exhibits?
No, I do not.
Mr. Heath, if I ask you the same questions that are set forth in your pre-filed direct testimony while you were on the stand today, would your answers be the same as is reflected in the pre-filed testimony?
Yes, they would.
All right. You're also the same Tom Heath that pre-filed rebuttal testimony in this proceeding on January 11th, consisting of 48 pages, and Heath rebuttal exhibits 1 and 2. Is that correct?
Yes, I am.
And was that rebuttal testimony, and were those exhibits prepared by you or under your direction?
Yes, they were.
And do you have any corrections to your rebuttal testimony or exhibits?
No, I do not.
And if I ask you the same questions set forth in your pre-filed rebuttal testimony while you were on the stand today, would your answers be the same?
Yes, they would.
All right. Chair Mitchell, DEC and DEP would move that Mr. Heath's pre-filed direct and rebuttal testimony be entered into the record as if given orally from the stand.
All right, hearing no objection, Mr. Jeffries, to your motion, the pre-filed direct testimony consisting of 37 pages of Mr. Thomas Heath, filed on October 26, 2020, shall be copied into the record as if delivered orally from the stand. Additionally, the rebuttal testimony of Mr. Heath, consisting of 47 pages, filed on January 11th, 2021, shall be copied into the record as if delivered orally from the stand. The exhibits to those testimonies will be identified as they were when pre-filed.
Thank you, Chair Mitchell. Mr. Heath, have you prepared a summary of your pre-filed direct and rebuttal testimonies?
Yes, I have.
Could you please provide that for the commission, please?
Sure. Good morning, commissioners. My name is Thomas Heath, and I am a structured finance director for Duke Energy Corp. I'm pleased to appear before you today to discuss the petition for storm recovery financing orders for Duke Energy Carolinas and Duke Energy Progress, which I will refer to collectively as the companies. In my direct testimony, I present the company's proposal to use storm recovery bonds to finance storm recovery costs as permitted by the securitization statute and to provide an estimate of upfront and ongoing financing cost. The companies request that the commission approve the issuance of storm recovery bonds to finance the full amount of the company's storm recovery cost related to Hurricanes Florence, Michael, and Diego, and Florence, Michael, and Dorian, and Winter Storm Diego. The statutory cost objectives of the securitization statute of providing quantifiable benefits to customers and structuring and pricing the bonds to result in the lowest storm recovery charges consistent with market conditions at the time the bonds are issued are clear, and the companies have proposed a financing structure that meets these objectives and provides significant savings for DEC and DEP customers compared to traditional base rate recovery. The companies have proposed options to either issue bonds separately for DEC and DEP or in a combined structure, which the companies believe are expected to attract greater investor attention and provide consistent bond terms and pricing for both DEC and DEP customers. These options are intended to permit flexibility for the offerings to achieve the statutory cost objectives, and it is important to note that no decision has been made to date as to exactly what structure will be utilized in the proposed transaction. My rebuttal testimony responds to recommendations proposed by the public staff consultants, clarifies the requirements of the securitization statute, explains how the company's proposals are consistent with the statutory cost objectives, and provides alternative recommendations regarding post-financing order procedures. The public staff's testimony was primarily focused on ensuring a continuing and by historic standards, an unprecedented and extraordinarily active role for the public staff in the post-financing order structuring, marketing, and pricing process for the storm recovery bonds. The companies have significant concerns with an arrangement that allows an intervening party, even the public staff, to have a decision-making role in a financial transaction that by statute is required to be performed by the companies, decided by the companies, and executed by the companies. In the event the Commission decides to weigh the applicability of the construct of the Duke Energy Florida, or DEF, bond team model to the company's proposed transaction in this case, I make it clear to the Commission that the public staff consultants did not accurately explain the construct of the DEF bond team, which they heavily rely upon in their testimony. While the companies believe this is ultimately a decision for this Commission, the companies would support a bond team consistent with the DEF bond team, which would be comprised of the companies, their advisors and counsel, and a designated commissioner or member of Commission staff, including any independent consultants or counsel hired by the Commission itself to ensure that the structuring, marketing, and pricing of the storm recovery bonds will achieve the statutory cost objectives. Commissioners, I want to make clear that the companies particularly reject the notions, which are often repeated in the public staff consultants' testimony, that DEC and DEP are presumptively unsuited or would have anything other than their customers' best interest at heart and mind during this process. The companies are keenly aware that the cost of all of their debt issuances are subject to ultimate recovery from their customers, and it is not in the company's best interest to do anything that would unnecessarily add to the cumulative cost of electric service that their customers must pay. This is as true of their past issuances as it is of the proposed transactions. And our track record of prior bond issuances speaks for themselves. After all, the fundamental purpose of securitization is to lower customer cost. And with this in mind, the companies have put together an indicative structure that, based on market conditions as of early October 2020, would save DEC customers $57.5 million and DEP customers $216.2 million over a 15-year period. That's over a 30% savings when compared to the traditional method of recovering storm costs through based electric rates. Further, the companies have proposed to certify to this Commission, through the issuance advice letter or otherwise, that the bonds meet the statutory cost objectives, and we take that willingness to certify very seriously. Lastly, The public staff consultants have proposed so-called, quote, best practices related to utility securitization transactions and implied that the company's proposed transaction is deficient because it does not include these so-called, quote, best practices. The facts, however, are that many of these recommended practices have already been incorporated into the company's proposed financing orders and transaction documents. The companies believe that the additional recommended best practices of the public staff consultants are not appropriate for the proposed transactions in these dockets, as they do not adhere to the securitization statute and deviate from established North Carolina regulatory practices. Since the filing of my rebuttal testimony, it is my understanding that the companies and the public staff have reached a settlement regarding ongoing financing costs and capital contributions, among other things. I'm happy to address any questions the Commission may have regarding the settlement agreement and these agreed upon issues. This concludes my testimony summary.
Thank you, Mr. Heath. Mr. Heath's available for cross-examination and questions by the Commission.
All right, Mr. Grantmeyer, Mr. Creech, you may proceed.
Good morning, again, Madam Chair. Thank you, Mr. Jeffries, and good morning, Mr. Heath. How are you? Can you hear me?
I'm doing well today. Yes, I'm doing well today. Thank you.
Good, good, good. Well, we're doing combined cross on your direct and your rebuttal testimony today, and so we'll start with your direct, but we may move around a little bit. But let's start with your direct. One of the purposes that you state in your direct on pages 3 and 4 is to support the joint petition of the companies, and I was hoping we could briefly turn to the petition just for a moment as a preliminary matter.
Sure, no problem.
All right.
I've got it before me, so I'm ready whenever you are.
Great. On the first page of the petition, it indicates a rationale for the petition and ends with a quote: "The companies estimate that securitization of the respective storm recovery costs will result in expected customer savings of 32% for DEC customers and 33% for DEP customers." Is that correct?
I believe that is correct.
On page 1.
I was looking at my testimony, sorry, not the petition.
Sorry.
I believe that is correct, though. Yes.
Okay. And to be clear, there's not just a customer benefit here, however. The companies benefit too, including the companies get paid back sooner and in full instead of having to await the company's next rate cases. And this debt cannot be considered corporate debt of the utilities by the Commission except for federal income tax purposes, correct?
That is correct.
And of course, it's the ratepayers who pay back these bonds, which is why you've heard them referred to as ratepayer-backed bonds, correct?
That is correct, but I would also clarify that, as I mentioned in my testimony summary, that customers are ultimately responsible for paying back principal and interest on all of our debt, whether it's securitization debt or our first mortgage bonds.
And in the joint petition, the companies, I think you mentioned, are proposing $1 billion in bonds, and that's approximately, that's to reimburse a quarter reimbursement back to DEC and 3/4 back to DEP. Is that right? Approximately.
Approximately, yes.
All right. Now let's turn to page 10 of the joint petition, if we can, please. In section 13 on page 10.
Yes, I'm there.
Okay. We're not going to do a lot of reading today because I know that's not preferred, but I would ask, because I think it's important in for our discussion today, that you please read the first sentences there, the first 8 lines, finishing in base rates, if you will.
Okay, I'm on the joint petition, but number 13, is that right under the offering of and sale of bonds?
It's on page 10, section 13, paragraph 13.
All right, hang on. I have, hang on just a second. Okay, I'm there finally. Sorry about that.
Okay. No, thank you. Would you mind reading the first 8 lines there down to ending the sentence base rates?
Sure. On November 6, 2019, SB 559 was signed into law establishing NC General Statutes, Section 62-172, to create a new financing tool to allow utilities the ability to securitize certain storm recovery costs. Securitization is a process by which the storm recovery costs, which the companies are entitled to recover, are not financed directly by the companies at their overall cost of capital. Instead, securitization makes use of relatively low-cost bonds, which are secured by an irrevocable right to bill and collect storm recovery charges and certain periodic adjustments to such charges. The storm recovery charges are separate and distinct from the company's base rates.
Thank you, Mr. Heath. And then the next sentence, I won't have you read it, but the next sentence indicates that the issuer of the bonds will be a bankruptcy remote special purpose entity, which we refer to as a SPE. Is that correct?
That is correct.
And so DEC and DEP themselves will not technically be the issuers of the bonds, but rather a bankruptcy remote SPE or SPEs, correct?
True, the SPEs are the issuer, but Duke Energy Carolinas and Duke Energy Progress will be co-registrants on the registration statement.
All right, and let's just finish reading the remainder of that section, if you will, and I think we'll be done with that. Starting because.
Sure. Because of the nature of the storm recovery property pledged to support the storm recovery bonds, the securitization process results in the issuance of highly rated bonds, usually AAA or equivalently rated, to raise the capital necessary to reimburse an electric utility for its previously incurred storm recovery cost and to pay the associated financing costs related to issuing the bonds and maintaining the structure to ensure timely payment of debt service on the bonds. This approach makes it possible to reduce each company's overall revenue requirement associated with storm recovery cost, thereby reducing costs to customers. The revenue requirement is lower because the securitization results in a lower cost method of financing storm recovery costs in comparison to traditional cost recovery and rate making methods.
Great, thank you. And then let's move on to in the petition to page 25, if we can. And there's a heading there that says securitization benefits.
So I'm there.
Okay, and then actually let's turn on to the next page, page 26, in section 46. And you see the sentence. You see the sentence there that indicates that the storm securitization statute, quotes, requires the commission to find that the proposed structuring and pricing of the storm recovery bonds are reasonably expected to result in the lowest storm recovery charges consistent with market conditions at the time the storm recovery bonds are priced in the terms of the financing orders. Do you see that?
Yes, I see that. I do see that.
Will you read the sentence right after that, starting with the final structure?
The final structure and terms of the storm recovery bonds will be determined shortly before their issuance in accordance with the financing orders. As described in the...
That's good, yeah.
Okay.
Okay, sorry about that. But I guess, so we will not know the final structure and terms and pricing of the bonds at the time of any financing order. Isn't that correct? Is that correct?
That is correct.
Okay. Let's turn to to page 27 of the joint petition, if we can. Just the next page and section 48.
Okay, on there.
And the first sentence there says, quote, to maximize the benefits from securitization for customers, it is necessary to obtain AAA equivalent credit ratings for the storm recovery bonds and, if applicable, the SRB securities. Isn't that correct?
That is correct.
And you'd agree that there are some very specific requirements that must be met for these bonds to achieve AAA rating. And among them are some of the items listed right in that next sentence, which are not, number one, non-bypassability. Number three, a mandatory true-up mechanism. 4, a requirement that the commission not amend or terminate the financing orders. 6, a statutory pledge that neither the state nor the commission will impair the rights of the storm recovery bondholders. Is that correct?
That is correct, yes.
Okay, and then finally, we'll move on from the petition here momentarily. Let's just turn to page 20, back to page 20. There's a chart there, kind of a flow chart. It says structure of issuance.
Yes, I'm there.
All right, and on the left-hand side there, we see DEC, with Duke Energy Carolinas. On the right-hand side, Duke Energy Progress. And really the point there is that DEC can create a SPE of its own, and DEP can create a SPE of its own, and potentially come together there at the bottom, that fourth box down, I suppose, to issue them jointly. And that's what the company is asking for flexibility for in this petition. Is that correct?
Yes, flexibility, but the flexibility is not just for that structure. It could be for the SRB structure. It could be for separate issuances for DEC and DEP, either at the same time or separated in time.
Certainly.
Yeah, but it's about flexibility for the best option to achieve the statutory cost objective.
All right. Now let's move to your rebuttal, if we may, your rebuttal testimony.
Sorry.
It's okay. And I want to, you mentioned on page 20 about the testimony of public staff witness Fischera, and I was going to bring up now our pre-marked Exhibit 5 to talk to you about witness Fischera's figures, but it looks like the functionality of that particular, some of those figures did not come through. They were all black, and so I would ask, actually, if you could potentially pull up, if you would please pull up the Fischera testimony, if you would, please. Witness Fischera's testimony.
All right. I'm there. Can you hear me? I'm on Mr. Fischera's testimony.
Perfect. Perfect. All right. Thank you. And if you could just turn to page 13 of Mr. Fischera's testimony. There's a figure 2 there, very reminiscent to the pre-marked 5, and hopefully you can see that. And witness Fischera breaks this whole process into 3 phases. And do you see what I'm looking at there? Phase 1, phase 2, and phase 3?
Yes, I do.
And just give me 1 second. And so under phase 1, a petition would be filed, testimony would be filed, discovery occurs, and following the hearing, possibly a financing order issued by the commission under this kind of framework. Is that correct?
That is correct.
And that would be followed by phase 2 that would have the implementation of the financing order. And that's, I think, what you refer to as kind of the marketing phase in your testimony. Is that correct?
I would say it's the structuring and marketing process.
Okay, right. And then finally is really the final period there when pricing occurs and the issuance of bonds. Is that correct? In the phase 3?
That's right.
Okay. So I just lay that out because I think we'll see that here coming up. Thank you for that very much. So I would like to continue on with your rebuttal, if I could, on a couple major themes that you touch on in your rebuttal. The first relating to whether or not this is your traditional bond issuance, and the second related to some of your references to a plain meaning reading of statutes. But before I do that, I would like to talk with you about your initial observations about the public staff's testimony in this case, which you indicated also in your summary today. If you go to page 4, lines 12 and 13 of your rebuttal.
Okay, there.
You indicate that you thought that the public staff's testimony should have focused more on the financing orders. Though you are aware of various observations the public staff witnesses made as to financing orders, including extensively in the testimony of former Texas Commissioner Klein in her Exhibit 2. Is that correct?
Yes.
And that the Commission's procedural order in this proceeding indicated that suggested revisions to the proposed financing orders be filed on or before February 8th, which is, of course, after this evidentiary hearing today. Is that correct?
Yes, it is, but I do believe that it would have been helpful at this stage to see a markup of exactly what was being asked for here.
Okay. Right now, I do want to move on to the themes I mentioned before. Let's turn to page 7 of your rebuttal. And in lines 9 to 11, you ask, quote, are the storm recovery bonds proposed for issuance in the pending dockets materially different from other long-term debt issuances by the companies? And can you please read the first sentence of your response there?
In my opinion, they are not. While I acknowledge that the structures used and the flow of cash are different than more customary long-term bond issuance, I do not believe those differences necessitate an entirely different process for approval and issuance of the bonds.
Okay. But as the companies seem to actually acknowledge in their joint petition, there are various aspects of these ratepayer-backed bonds that are not normal. This process now, of course, has its own statute, does it not?
Yes, it does.
And the statute authorizes to the Commission to issue one or more financing orders which impose a specific charge on all customers' electricity in a public utilities historic service area, correct?
That's correct.
And a financing order that declares that the right to impose, adjust, bill, and collect that charge to be a present interest in property which can be transferred to a bankruptcy remote SPE, correct?
Correct.
And pledges that the state legislature and the Commission cannot revoke or amend the state statute or the financing order in a way that will adversely affect holders of the bonds, correct?
Yes, all that's correct.
And that the storm recovery charges will remain in place, quote, even if a customer elects to purchase electricity from an alternative electric supplier following a fundamental change in regulation of public utilities, end quote. Is that correct?
Yes, it is.
Now, and as a result of these features, ratepayer-backed bonds are typically assigned the highest possible credit ratings, correct?
Yes.
And they're not treated as debt of the utility for purposes of the credit rating agencies assigning ratings to the utilities' other securities, correct?
No, that's incorrect. For S&P, Standards & Poor's does unconsolidate it, but Moody's does include it as on credit. And this debt is, even though the statute and the financing order will say that this is not debt of the utility for any purpose other than federal income tax purposes, the fact is this debt is consolidated onto the balance sheets of DEC and DEP for SEC filing purposes. And that is generally what the rating agencies look to. So Moody's sees it as consolidated, leaves it as consolidated, does make some qualitative adjustments for it. S&P would strip it out.
Are you suggesting that the financing order would be incorrect?
No, the financing order, I believe, and this comment about this being debt, not treated as debt of the utility, is for rate making purposes and for income tax purposes only.
But to be clear, it's not debt of the parent. It is only debt in the consolidated balance sheet. Isn't that correct?
No, it's not debt of DEC and DEP for rate making purposes. It is debt of DEC and DEP and Duke Energy Corp for consolidated financial statement purposes.
For consolidated purposes. Is that correct?
Yes. Yes.
All right. Now for DEC, let's see here. And we were talking about traditional utility bonds. And again, with respect to traditional utility bonds, the state legislature and the commission could conceivably revoke or amend the state statute or the state commission's order, the utility commission's order, which authorized issuance of the traditional utility bonds in ways that adversely affect holders of the bonds. Is that correct?
Could you clarify that question or repeat that, please?
I guess I'm going back to the point about the state pledge, and so and the commission. So for these bonds, there's got to be a pledge that the state legislature and the commission cannot revoke or amend the state statute or the financing order in a way that will adversely affect holders of the bonds. That's correct, is it not?
That is correct. Yes.
All right. Well, we'll move on. Now for DEC, how many of these ratepayer-backed bonds, storm securitization issuances has the company completed?
None.
And for DEP, how many ratepayer-backed bond, storm securitization issuances has the company completed?
None.
And as for their parent, how many such issuances has the parent completed?
Their parent company, none, but their affiliate, Duke Energy Florida, did a transaction for almost $1.3 billion in 2016.
So they have an affiliate who's done one.
Correct.
Okay. All right. Let's move on to another theme in your rebuttal, if we can, the so-called plain meaning or plain reading of the statute, which is mentioned by my count about 5 times in your rebuttal. But so I'd like to first, if I may, talk to you about the statutes, if we could, and specifically, I would like to, Madam Chair, I would like to pull pre-marked Exhibit 1, the public staff pre-marked Exhibit 1. Which is pages 1 to 21.
All right, Mr. Creech, identify the document that you're looking at, please.
Yes, at the very top, it's a 62-2 Declaration of Policy.
Okay.
All right. And I would like to mark this as public staff. We'll have to get our naming convention here today, so I'd like to do it exactly how the commission would like. Public staff cross-examination, public staff Heath cross-examination Exhibit 1. How would you?
Let's identify the document as public staff Heath Cross-examination number 1. Public staff, Heath, cross-examination number 1.
Thank you. Mr. Heath, you'll be pleased to know we're not gonna read a ton of this statute, but we will briefly touch on it. So this pre-marked the public staff Heath cross-examination exhibit 1 is actually comprised of 3 statutes, one underlying the commission, the other underlying the public staff, and the third being the storm securitization statute. Do you see subsection? If you turn to page 2, the second page of the document, to subsection B.
Yes.
And it reads that, quote, authority shall be vested in North Carolina Utilities Commission to regulate public utilities generally, their rates, services, and operations, correct? See that?
What paragraph do you see that in?
Right. I'm sorry. It's in the under B. It's really the first 2 lines.
Okay.
There. To these ends, therefore, authority shall be vested. Okay. All right.
Yeah, I see that.
All right. Now let's turn over a couple more pages if we can. And at the top of the page, it says 62-15. This is a public staff.
Yep.
All right. And do you see under subsection B there, it says there is established in the commission a public staff period?
Yeah.
Okay. And let's scroll down just a moment more down to D. And do you see the word shall there, the second word?
Such personnel shall be fixed.
No, I'm sorry. Under D there, it shall be the duty and responsibility of the public staff too. D as in David.
Yes. Yeah. Sorry.
Okay. And the listing that follows there, you see that it includes reviewing and investigating certain matters there in items 1 and 2, numbers 1 and 2, review, investigate, etc.
Correct.
And in item 3, it indicates shall intervene on behalf of the using and consuming public in all commission proceedings affecting the rates or service of any public utility, end quote. Is that correct? You see that?
I see that, yes.
Okay. And then finally, and I think this is important, let's go down all the way down to 12. And could you read number 12, please?
Sure. When deemed necessary by the executive director in the interest of the using and consuming public, advise the commission with respect to securities, regulations, and transactions pursuant to the provisions of Article 8 of this chapter.
Okay. And as you probably realize, the legislature placed the storm securitization statute that involves securities in Article 8, which is entitled Securities Regulation of Chapter 62. Is that correct?
I believe so, yes.
Okay. Now, speaking of securities, let's turn to that issue for a moment if we can, because you've raised that issue in your testimony if we can. So let's go back to your rebuttal. And on pages 25 and 26 of your rebuttal, it's the bottom of 25, top of 26.
Okay.
Okay. You state, quote, it's starting at the answer there on page 25, line 19. You say, quote, under federal securities law, DEC and DEP will be the issuers of the underlying bonds in this instance, and as such, will have all the obligations under the federal securities laws with regard to such issuances. Do you stand by that statement?
I guess I would probably clarify that DEC and DEP would be co-registrants along with their SPEs, who are the issuers. Those SPEs are wholly owned by Duke Energy Carolinas, or will be wholly owned by Duke Energy Carolinas, Duke Energy Progress.
Okay, and thank you. And those And that was borne out in your response to a data request 16, as I recall. Does that sound familiar to you? Public staff data request 16?
It's very possible. I mean, there were many data requests, and it's hard to remember exactly what every one of them covered, but that's probably likely.
Okay. Let's just two other aspects on this. You have attached to your testimony forms of transaction documents proposed by the companies, but they do not require the companies to indemnify these SPEs for money damages imposed by reason of securities laws violations. Is that correct?
I believe there is a commission. There's a condition that we make the customers whole for any losses that are sustained.
Okay. And any unindemnified money damages imposed by reasons of any securities law violation in connection with the issuance of storm recovery bonds would be a financing cost, which the SPEs are entitled to recover from storm recovery charges. Is that correct?
I believe that would require a legal opinion. I'm not really an attorney, but
Understood. I'm not asking for legal opinions here today. We'll move on then. You were involved in the DEF storm securitization transaction in Florida. Is that correct? Duke Energy, Florida.
that is correct. Yes.
Okay. And was there any securities law violation alleged, or did one actually occur as relates to Duke Energy, Florida?
There were not. No.
The Florida Commission?
Not that I'm aware of.
Its advisor that's also serving as the public staff's advisor in this case?
No, there were not that I'm aware of, but, I don't think we manage risk on whether or not something, whether there was a claim. We look at the potential for there to be a claim.
Okay, let's move on if we can. So we move on kind of to the next topic here, and maybe a little harmony for a moment. You asked the commission at various to look at various items. Let's see here. We're on pages 10 and 11 of your rebuttal.
Yes.
And it's at the bottom of 10, going into 11. You mentioned various of the public staff's proposals, our proposals, and I just wanted to, in the first three relate to best practices, certifications, and either bond team and or public staff involvement. And at least on those three levels, in terms of a matter of degree, best practices, certifications, and public staff involvement, there is some level of agreement in this case and perhaps some level of disagreement. Would that be fair characterization?
Yes, but I think on the specific topic, there's, there may be more common understanding. There may be wider differences of opinion on others.
Okay. Now let's turn to page 19 of your rebuttal, if we can. And this goes to where you speak of the company's view on the lowest cost objective or standard for issuance of the bonds.
Yes, but I think it's really looking at what the statutory objective is. Yes.
Okay. Very good. And this relates back to our discussion of you're calling for a plain reading of the statute, so that's good, and as well as our prior kind of original characterization or discussion of characterizing this process in phases. Phase one, that we're now in, phase two being the marketing, structuring, and pricing of the bonds, and then phase three being the final period where certifications occur and we press go and bonds are issued. If you can,
Mr. Creech,
yes.
I'm sorry to interrupt.
Please.
I don't think your characterization of the phases, I don't think was consistent with Mr. Heath's characterization of the phases. So we might want to clarify that. I think it's a record maybe confused on at this point.
Thank you, Mr. Heath. Did you, and my apologies, Mr. Heath, did you want to clarify any point on that?
I mean, there are certainly stages to this, right? There's financing order, there's post-financing order. I think we, when we talked about Mr. Fischera's testimony earlier, he had that broken into 3 phases. I think I look at it as there's the petition and there's a post-financing order process.
Okay. All right. Thank you. Thank you, Mr. Jeffries, as well. All right. Now, as we're on page 19 of your rebuttal, and can you read your question and answer at the top of page 19, if you will, there? Does the securitization statute outline the lowest cost objective? Could you, I suppose, read your answer there? And you can feel free to skip down to number 2 after you start, or you can read the whole thing, either way.
Okay. Yes, the North Carolina General Statute, Section 62-170 requires 1, that the issuance of the storm recovery bonds and the imposition and collection of a storm recovery charge are expected to provide quantifiable benefits to customers as compared to the costs that would have been incurred absent the issuance of the storm recovery bonds. And 2, the structuring and pricing of the storm recovery bonds are necessarily expected to result in the lowest storm recovery charges. Consistent with market conditions at the time, the storm recovery bonds are priced in the terms set forth in such financing.
Thank you. Let's turn to the securitization statute, if we can, which, as you may recall, we marked that as Public Staff Heath Cross-Examination Exhibit number 1. And you can go over to page 7, which is Session Law 2019-255. It's page 7 of that document, the securitization statute.
Yeah, I believe I'm there.
Okay. Obviously, Section A there is definitions, and let's scroll down to Section B, if we can, which is actually on page 9 of the overall document, page 3 of the statute. It says financing orders. See that?
No, I'm not following your page references there.
I'm sorry, just the 3rd page of that particular statute at the bottom of the page says financing orders B.
Understand? Yeah, right. I'm there. Yeah.
I was just trying to get us momentarily, and then we're actually gonna go over, and then we're actually gonna kind of continue flipping over, if we can, one more page to 3, to number 3 there at the next page, which says petition and order.
Yes, I see that.
All right, and thanks for your patience on that. And then finally, under that section, we go to B, which is on the next page, which is page 11 of the overall document, page 5 of the securitization statute. It says It says, quote, a financing order issued by the commission to a public utility shall include all of the following elements. Does it not?
Yes, it does.
All right. And you see there that, and you just read from your rebuttal, items 1 and 2, you see that those correspond really with items B2 and B3 just below there. Do you not? A finding that the proposed issuance, and then a finding that the structuring and pricing. Do you see that?
Yes, findings that the commission has to make, yes.
Okay, all right. Now, going back to page 19 of your rebuttal testimony, that we had you just read at the top on your answer, it says, yes, NC Gen Stat 62-172 requires. But should it be revised to add reference to the financing order, as the statute requires that it's the financing order include those two items, such that Your answer on page 19 of your rebuttal should instead read, yes, NC Gen Stat 62-172 requires that the commission's financing order include those two things.
Chair Mitchell, we'd object. I mean, Mr. Creech is free to ask Mr. Heath a question about his testimony, but I don't think having him try to attempt to correct it on the record is appropriate.
I'm pleased to move. I'm pleased to move on. I was just trying to make a particular point about the plain reading of the statute.
All right, I'll sustain the objection. Please move on, Mr. Creech.
Okay. Continuing on with this line of questioning, however, in a different way, let's go to the final provision of item 12 of the statute. Again, the next page. So again, we're now down to B12 on the very next page of the statute. And thanks for your patience. And do you see there, Mr. Heath, where it says, quote, any other conditions not otherwise inconsistent with this section that the commission determines are appropriate, end quote?
Yes, I see that.
Okay. All right, now let's briefly talk about the pricing of the bonds, if we can. All right.
Okay.
And it may be that witness Atkins, to whom you regularly refer in your rebuttal, can also speak to this. And of course, he'll be on later today. This relates to the company's contention that all the bonds need to have actual buyers, actual orders from buyers for 100% of the bonds at the time the bonds are to be sold, selling the bonds at a so-called market clearing price. Is that correct?
Yes.
Okay. Now, do you think it's advisable, whether you're selling 1,000 bonds or 1,000 of anything or renting 1,000 of anything, if you could get a great price for 95% of something, the bonds, wouldn't you rather do that than to go about getting a lower price overall and getting lower gross receipts overall by having to sell them all at once?
I don't think I follow that question. I mean, I think if you're asking about, do we want to have the bonds fully subscribed? Yes, I do. I don't think that anything other than having orders for the bonds is a market clearing price. I mean, forcing trying to get an underwriter to buy them at some other price to drive down a rate or something like that, I don't think is appropriate. I mean, these should be fully marketed bonds, and this should bear the rate that is going to be available in the market.
I guess my point is would it be a fair analogy to say if you could, if you can get an optimum price for 95% of these bonds, that you're saying that no, we've actually got to sell it potentially at a lower price so that we get them all sold at once. We cannot have the underwriter hold on to the final 5% there and take some level of risk. Is that what you're saying?
Yeah, for it to be a market clearing price, they need to be fully subscribed and sold.
Notwithstanding the fact that could mean lower gross receipts, or excuse me, in that type of setting, a less than optimum result.
I wouldn't describe that as less than optimum. I mean, the market clearing is how bonds are, market clearing rate is how bonds are priced in the public markets.
Okay. I hope we can move on to two final things if we can. One is from your rebuttal, and the other is your direct testimony.
Sure.
All right. First relates to public staff witness Abramson in your rebuttal, and then in your direct testimony relating to transaction documents. So let's first look at your rebuttal on page 32, starting on line 7.
Okay.
You state that given his 40 years of experience covering U.S. Utility sector in general and Duke Energy in particular, and so you continue, you reference public staff witnesses Abramson's experience covering utility bonds, do you not?
Yeah, I do.
Okay. And do you happen to have, I'd like for us briefly to turn to witness Abramson's testimony if we could.
Okay, give me a minute. Give me a minute.
All right.
Okay.
All right. Let me get there if I can also. All right. Thank you. And let's turn to pages 6 and 7 of witness Abramson's testimony.
Okay.
And line 17 in particular. You see the heading that reads, achieving the best possible outcome for ratepayers is also good for relations between the utility and its regulators, a key factor for investors. Is that correct?
I do see that. Yeah.
And do you see where he goes on to say, quote, in addition, a securitization bond offering that provides ratepayers the best possible outcome, namely the greatest savings, would be viewed favorably by state regulators, in my opinion. Knowledgeable long-term investors in utility stocks and bonds understand that a good regulatory environment is important to the long-term success of their investments in regulated monopolies. Is that correct? Then the final aspect of your testimony I'd like to touch on are the transaction documents, if I can, and that's exhibit, kind of the various exhibits to your direct testimony.
Okay.
All right. Now, with respect to these transaction documents, in most of these, there are two parties to these agreements, one being the utility and the other being its wholly owned subsidiary, SPE. Is that correct?
Yes, for some of them.
Right. And so essentially it's the utility contracting with its own SPE. Is that correct?
Yes, or I would say it's the other way around. The SPE contracting with the utility. The utility is going to service bond. It's going to be the administrator. It's going to sell the property right to the SPE and those sorts of things.
Certainly, certainly. Thank you. Thanks for that clarification. And in light of that, let's turn to customer protections in those agreements. And on page 35 of your direct testimony, on page 35 of your direct testimony, you ask the following question. In DEC and DEP's affiliates transaction in Florida, the financing documents contain certain provisions that the Florida Commission viewed as customer protections. And then we say, do the financing documents that you are sponsoring contain similar customer protections? Do you see that?
Yes, I do.
And you replied, yes, it's my understanding that they do. Is that correct?
That is what I said. Yep.
All right. All right. I think we could go through several of these transaction documents, but we won't go through them all. I'd like to primarily just look at the servicing agreement, if we could, please. All right. Now, And in doing so, I would like to, Madam Chair, if I could, bring up public staff pre-marked 13. Which is the Duke Energy Florida DEF servicing agreement.
All right, Mr. Creek, give us the page numbers for that exhibit.
Shall do. Just 1 second, please. And thank you. I thought I had it. Just 1 second. I'm sorry.
I've got it, Mr. Creech. I believe it's 529.
529, I'm sorry.
Is that consistent with your records?
Let's see here.
Mr. Creech, we're looking at the Nuclear Asset Recovery Property Servicing Agreement. Is that right?
The Duke Energy Florida DEF servicing agreement. Correct.
Okay.
Having a technology issue here. Excuse me 1 second.
Okay.
Thank you. That's correct. Thank you. Thank you so much. Page 529.
Okay. Let's give everybody a minute to find the document. That is the Nuclear Asset Recovery Property Servicing Agreement. That page number down at the bottom is 529. Mr. Creech, would you like to mark this exhibit?
I would, please. I would like to mark this exhibit as Public Staff Heath Cross-Examination Exhibit 2.
All right, the document will be marked Public Staff Heath Cross-Examination Exhibit 2, Exhibit number 2. All right, you may.
And right, Mr. Heath, this is a service agreement executed by DEF in connection with the 2016 Florida ratepayer-backed bond transaction. And Section 5.04 describes the circumstances under which DEF may resign as servicer. If we can, let's go down to that.
I see section 5.04 to be effective date and termination.
All right. And will you read the last sentence of that section, please?
Duke Energy Florida shall not resign as servicer if such resignation does not satisfy the rating agency condition or without consent of the commission.
Okay. So, and let's go to your the form service agreement attached to your direct testimony.
Okay. I'm not sure I have that in my binder here.
That's okay.
Yeah, I think I only have my exhibit ones. I don't believe I have the form of documents here unless someone can direct me to them.
Okay. That is Exhibit 2B, which is the form of storm recovery property servicing agreement.
Yeah, I know it's an exhibit, but I don't think it's in my materials here.
Okay. All right. Let's see here.
Yeah, I'm just not seeing it here with my testimony in my binder.
Chair Mitchell, this is Kamal Robinson. For whatever reason, I'm not sure why we didn't get him that, but I can get that to him in about 2 minutes if you give us a second to get him that document. I can email.
We'll take a brief hold while Mr. Robinson, you get the document to the witness. Thank you.
Thank you, Chair Mitchell. Chair Mitchell, you should have it any second now. Mr. Heath, if you wouldn't just check your email, please.
All right. Thank you, Mr. Robinson. Mr. Heath, why don't you let us know when you have the document?
I have it opening up now. It should just do a second. I have it open and I'm in section 5.04.
Perfect. And thank you. And then again, that's right. Page 13 of that document, but page 542 of the overall combined exhibits. All right. Can you please read the final sentence of that 5.04?
Sure. It says Duke Energy Carolina / Progress shall not resign as servicer if such resignation does not satisfy the rating agency condition.
Right. And that's different from the DEF final sentence, is it not?
Let me get back to it. I think there's something different there. Yes, the DEF agreement also has the words at the end, or without consent of the commission.
All right. Now, I guess the point is, you've indicated in your testimony that it's your understanding that the financing documents attached to your testimony, let's use your words here, contain similar customer protections as the DEF transaction documents. Is that correct?
That is correct.
But in this instance, there could be a servicer that the utility could resign as servicer and inform the rating agency, but not the commission. Is that correct? Under the forms you submitted, or not you submitted, but attached to your testimony.
It says without the Florida agreement has the words without consent of the commission. So I'm not sure that we would not notify the commission at least. I do think that I thought we did have that provision in there. I know we're not trying to limit the commission's ability on anything here. So if that was an oversight, we certainly apologize for that. I know we weren't also there in some aspects, we weren't trying to presume that the commission wanted to have the ongoing responsibilities and obligations that the Florida Commission accepted in the Florida transaction. So that was part of our consideration as well.
All right. And this is just merely one of several transaction documents. Isn't that correct, Mr. Heath? The service agreement.
Yes, there are many. Yes.
Okay. All right. Well, we could continue to go through some of these documents, but I think that will be it for now, Mr. Heath. I really appreciate your time, and thank you. Thank you, Commissioner.
Welcome.
All right, Mr. Jeffries, any redirect for the witness?
Thank you, Chair Mitchell. I have just a couple of questions. Mr. Heath. Mr. Heath, do you have Public Staff Heath Cross-Examination Exhibit number 1 handy? That's the package of statutes that Mr. Creech was.
Yeah. Yes, I'll get to it. Yes, I'll get to it in just a second. Okay. I have. Okay.
All right. So starting with the second statute in that packet, which is 62-15, which begins on page 4 of that package.
Yes.
Mr. Creech asking you, and to be clear, and I think everyone understands this, but 62-15 is the portion of chapter 62 that talks about the public staff's duties and responsibilities. And you recall he asked you down under D, I think he asked you to look at a couple of those provisions, and ultimately he pointed you toward paragraph 12.
Yes.
And this is a description of what the public staff's, the lead-in language to that laundry list of duties and responsibilities is it shall be the duty and responsibility of the public staff to, and then it's 1, 2, 3, 4, 5, 6, all the way down 12. And
correct.
And 12 says, when deemed necessary by the executive director in the interest of the using and consuming public, advise the commission with respect to securities, regulations, and transactions pursuant to the provisions of Article 8. Correct?
That's correct.
And I think we all agree that 62-172 falls within Article 8. My question to you is the word advise there, does that, in your opinion, is that equivalent with the proposal to make the public staff a co-equal decision maker in the issuance of these bonds, in your opinion?
In my opinion, no, it's not. Advising the commission is is not what the public staff proposed in their creation of a bond team in which they would have joint decision-making authority with the company.
Do you have the Duke, does DEC and DEP have any issue with the public staff advising, at least as you understand that term, the commission on your phase 2 of the process of the structuring, marketing, pricing process?
As I understand advising, and I would really state it in terms of, I believe they have a role to advise a bond team should the commission decide to implement one. And that bond team would consist of the companies, their advisor and counsel, as well as the commission or a designated commissioner or member of commission staff, along with their advisor and counsel as joint decision makers on this transaction in all aspects of the structuring, marketing, and pricing of the bonds. And I would see underwriters, other parties, including the public staff, as advising that bond team, advising those two joint decision makers. But those joint decision makers, again, the company and the commission, would be to make final decisions and as to how we structure, market, and price these bonds. I don't believe it's appropriate based on this statute or the securitization statute for the public staff to have a role that it has proposed.
Thank you, Mr. Heath. Mr. Creech also raised the prospect of ask you a couple questions about a market clearing price and the prospects that you could sell 95% of the bonds, but apparently not sell the other 5%. Could you provide at a 50,000 foot level for those of us that aren't experts on issuances of corporate bonds? How does this pricing process work? How does the marketing pricing process work for these kind of securities?
Sure, I'd be happy to. Typically, in most corporate bond issuance, there is an evaluation by the issuer and its advisors and underwriters where we would look at comparable securities of equivalent duration or tenor. So we're looking here maybe 15 to 18, 20-year bonds. We would look at comparable securities at those levels, and we would come up with some expectation of pricing levels for those bonds. Based on that collaborative effort as well, we would come out with an idea of a initial price talk, which would typically be something probably a little wider than where we would expect the deal to clear, so that when we go out and talk to investors and that we're giving them something that kind of incentivizes them to start getting attracted to the offering or having interest in the offering. And through different rounds of price discovery, we would build an order book along with the underwriters. And so these different investors would come into the book with a indication of interest at some pricing level, or really at that IPT level. And as we built that book, we would look and see how many orders are in there, at what level, and what sort of pricing sensitivity those investors might have. And based on that understanding, we would look and say, okay, well, now we can lower that spread a little bit. So give me an example, We go out with an initial price talk of 100 basis points or 1% on top of the underlying treasury rate. And we get a lot of interest at that level. And say we're trying to sell $500 million worth of bonds. We get orders for $600, $700, $800 million, maybe more. We know that there's more interest than we need for that book. So we might go back out to investors and say that 100 basis points is now 90 basis points. Some of those orders might fall out of the book, but we still end up with more orders than we need to fill that book. So now instead of 800 million, maybe that's 700 something. And then based on what we understand to be the pricing sensitivity there, are there big orders in that book that they're going to fall out completely if we lower this spread another 5 basis points or another 10 basis points. And so again, based on that understanding and talk with our underwriters and what we know of investors from our marketing effort, we would then make a decision as to whether further compress that pricing. We may go back out and say, now that 90 is 85, and we'll see how that looks again. So there may be multiple levels of kind of cutting that spread level till you get to a point where, okay, we've got 500, or maybe we're down now to $600 million worth of orders, but I know there's someone who in here with $100 million or maybe 2 people with $75 million orders. And if I push any more, those orders may go away completely. And if that happens, then I haven't sold $500 million worth of bonds. And so that discovery process is I would not call it a science. I would call it an art as to know how far to push. And you really have to understand the quality of your book and what the pricing sensitivities of those investors are.
Thank you. Could you explain, why is it important with respect to storm recovery bonds to sell 100% of the amount that's authorized?
I don't think it's just with respect to storm recovery bonds. I think that's applicable to every public issuance or every issuance of debt in the public markets. We take that same approach for our holding company issuances. We take that same approach for all of our first mortgage bond issuances at DEC and DEP. That for something to really get to a market clearing level, what the market is going to bear, those bonds should be fully subscribed and sold.
What could you help me understand again? I'm a layman. I'm not an expert on this stuff, but what are the practical consequences if you sold less than 100% of the storm recovery bonds in this particular context? What does that mean for the company?
Well, it could mean that the bonds that we don't have a successful deal, right? So it could be that if we don't have enough orders to fill and the underwriters are not willing to buy those at a discounted price, then we don't have a completed transaction.
One last question, Mr. Heath. Mr. Creech asked you some questions about your rebuttal testimony. I believe it was page 35.
Yes, I'm getting back to that in a second.
Yeah, I actually am looking at this. I think maybe now I have the wrong page reference. It was the discussion about customer protections.
Yes.
You recall that?
Yes, that's in my direct testimony.
Oh, okay. That would explain why I can't find it in your rebuttal. You made some statements in there about the documents and this deal having some of the similar protections that were included in the Florida transaction. You recall?
I do.
And then Mr. Creech went from there and flipped over to the transactional documents and started asking you some questions. But is it you explain what protections you're talking about in the following Q&A, don't you, in your direct testimony?
Yes, I do.
Okay. That's the purpose of the discussion after your statement that these transactional documents contain some of the same protections, right?
Correct.
Okay, thank you. That's all the redirect I have for Mr. Heath.
All right, thank you, Mr. Jeffries. We will now take questions from commissioners. I will start with Commissioner Brown-Bland.
Mr. Heath, just a moment ago, Mr. Jeffries asked you to speak in lay terms about what certain things would mean, and you ended that series of questions indicating if the underwriters didn't buy all the bonds, that it would mean you didn't have a completed transaction. Could you just carry that out to its logical conclusion? What does that in effect mean for the company?
I guess there's a couple implications. One is we could come back to the market at a later date, kind of, pull the deal, come back, approach the market a couple months later. The result would probably be maybe even wider pricing than where we thought we would land initially because of that first unsuccessful transaction. I guess it could also mean that we just decide to not go forth with securitization at all and seek to recover the storm recovery costs through the storm recovery rider that we've proposed in the pending rate cases.
So the bottom line is it means issuing the bond. Is that right?
It could mean that you can't issue the bonds, or it could mean that you maybe go to the market later and you have you may not end at the pricing where you thought you would initially.
All right. Thank you. That's all my questions at this time.
Okay, Commissioner Gray.
Thank you. Mr. Heath, has DEF ever tried to issue these storm securitization bonds?
No, Commissioner, we have not. There's been 2 securitization issuances in the state of Florida at all. One of those was the DEF nuclear recovery securitization that was done in 2016. There has been a storm recovery issuance that was done by FP&L prior to that.
As a follow-up, were both subscribed at a 100%, or following up on Commissioner Brown-Bland's thought, were any of them not issued because they were not fully subscribed?
So in the DEF transaction, it was a negotiated transaction like we're proposing here, where we go to the market in this process that I talked about. That transaction was fully subscribed and with some slight oversubscription, right? So if we're selling $1.3 billion worth of bonds, there were orders for, call it $1.5 billion or something like that. So it was fully subscribed, actually a little bit oversubscribed. The Florida transaction was actually done in a completely different process, and it's the only securitization bond that I'm aware of that was done in that manner, where it was really an auction process conducted with several banks, where FP&L got banks to just bid on the transaction. They came up with, they picked one to go forth with. They sold all of those bonds to that bank, and then I don't know if that bank held those bonds or they turned around and then kind of sold them in a secondary type market. But the DEF transaction was fully subscribed.
In the Florida Power and Light program, did the banks step in when FP&L was unable to conclude their own effort? And is that an option in this jurisdiction?
The banks bought the entire deal through a competitive bid process. That would be an option, but we believe that the negotiated sale process that I just talked about is the way that we should approach it. That's how the vast majority of public debt issuances are done in the market, whether they're securitization bonds or kind of general corporate bonds.
Thank you. That's all my questions now.
All right, Commissioner Clodfelter.
Yes, thank you, Mr. Heath. Can you hear me fine?
Yes, Commissioner, I can.
Great, thank you. I have just a couple of questions. I want to ask a couple of things about the option to use the grantor trust structure. And I can draw some inferences of my own, but I want to hear you talk about it rather than me speculate about it. Talk about what considerations would come into play that would cause you to determine that the use of a combined issue through the grantor trust structure is the way to go, as opposed to separate issues by the two SPEs? Okay. When would you choose? When would you choose to go the grantor trust route?
So we have it as an option today. Again, as I mentioned, we're not, we haven't decided that's the way to go, but we would need to continue to research it. We would like to have underwriters involved and get their opinion on the best way to execute, looking at everything that's out in the market at that time. I mean, I think we're talking about a realistically kind of a mid 2021 issuance. So, I think the decision has to be made a couple of months probably in advance of that. Just from the standpoint, you've got transaction documents to put together and things that, you really need to know which way you're headed, whether it's combined issuances or separate issuances. So I would speculate a couple months prior to really being in the market. You got to know what you're asking the rating agencies to rate, and that has to come before you're in the market.
Well, I appreciate that. I guess let me go to really the core of what I want to explore with you. Let's suppose that you're in that process and you conclude that there is benefit to one of the two SPEs from a combined issue and a different level of benefit, or maybe no benefit at all to the other. I mean, you've got different sizes here. You've got DEP's got a much larger nut that it wants to crack here than DEC does. And let's assume that you conclude that it's a benefit to DEC to tag along and have a combined issue, but maybe that's not so beneficial to DEP. Maybe it's not really important one way or the other for DEP, take it or leave it. And you conclude that there's a differential there. How do you allocate, how do you propose, and this is, maybe it's in the documents, but I'm not deep enough in the documents to know the answer. So I'll ask you. So how do you propose then to allocate the incremental costs associated with the combined issuance through a grantor trust as between the two entities, the DEP entity and the DEC entity? How do you allocate those costs?
That's an excellent question. And what we've laid out in my exhibits is we do show upfront transaction cost, assuming an SRB issuance to try to give clarity. And so those incremental costs today, we have allocated kind of on a pro rata basis of the issuance, right? So we're talking about this over $700 million for DEC or DEP and roughly 200 million or a little bit more for DEC. So we've allocated based on those percentages. But yes, as we go through time and continue to evaluate this, I mean, I think there's clearly a benefit to DEC. I think there's a slight benefit to DEP, but as we go through that analysis, and if we see that DEP would get no better deal than if it just went out on its own, and all the benefit of that combined issuance economically is DEC's, we would definitely consider giving all of those incremental fees to DEC.
You would consider it, and that's, I appreciate that, I respect that, and I accept that. I guess the old phrase was trust but verify. So how in the world would that be built into the structure to ensure that that occurred? How could we reasonably ensure that that occurred?
Sure. So we contemplate in our initial proposal, as well as in our kind of revised proposal that we laid out in our rebuttal testimony, that there is certainly a means for the commission to stay involved throughout this process, and it's really up to the commission to decide how involved it wants to be. So at a minimum, in our initial proposal, we were laying out an issuance advice letter process. So where we would deliver to the commission in advance of going into the market, a letter that showed expected pricing on the bonds, as well as an updated estimate of transaction expenses. And if we would have that either allocated to DEC and DEP if we believe both benefited, and we would have some discussion about that. If it was strictly a DEC benefit, we would show that in those updated exhibits, and the commission would have clear insight into which way we're thinking. Okay.
Thank you. That addresses, I think, the point I was driving at is that when we get the issuance advice letter, we're not just getting the final outputs. This is the pricing, this is the structure, but we get the undergirding, the rationale that supports that. We get the backup, in other words, how you arrived at that and why you arrived at that. All right. Well, I'll let that stand for now. That's good enough for present purposes. Let me ask you another question, and really it's about market timing. You said you're anticipating right now, perhaps something in the order of mid-2021 to go to market with these. As I understand the statute, and I think I'm reading it correctly, is there really is no limit on the timing. You can go to market when you want to go, if ever, or you can go when you want to go, if ever. And as I read the statute too, you went through this with Mr. Creech. One of the two financing conditions or structuring conditions is that you we need to find that your pricing will result in the lowest storm recovery charge consistent with market conditions at the time. So as long as you're at or better than market at the time you go to market, you've met that condition. My question to you really is, what kind of protection do we have about you mistiming when you go to market? You go into a bad market or a less favorable market, and suddenly we find that the net present value differential to the ratepayers has shrunk. It's no longer 30 million, it's only 15 million now because you mistimed the market. You've met the statutory condition because you are selling into the market at a price and in a structure that is the best in the market conditions at that time. You've met the condition, but you just mistimed. What's my protection there? What's my protection? What's the ratepayer's protection? I'm sorry. What's the ratepayer's protection? I'm a ratepayer. I'm a ratepayer.
I am too. But
what's the ratepayer's protection?
It's really with, so especially as we've laid out in this bond team where the company and the commission, a designated commissioner or commission staff member, joint decision makers, that would be the way that we would, we'd consider all of that. It's not just how we structure, market, and price the bonds, but when do we go into the market and figuring out the most optimal time. I think in the other manner, it would really be through the issuance advice. So we would give you information, say, here's why we think, the timing is appropriate now.
All right, I want to think on that one some. I'll take that answer, but I'll need to think some about that, whether that works. Let me ask this question on the same topic, but ask it this way. We're in a fairly decent market right now. What if the financing order had as a condition that you had to use it or lose it by some date certain in the future? How would that affect things?
I guess we would have to know what that date were, right? And I'll give you a little bit of an understanding of what the runway leading up to an issuance is. And I think we've talked about this a little bit in testimony. And we've committed in our testimony to get into the market, or to pursue, rather, I think the term was to pursue an appropriately aggressive approach, timeline rather, to get to market after the receipt of the financing order. But as we talked about in my cross-examination, the issuer on these bonds is the SPE, the utilities or co-registrants there. So this is a brand new issuing entity. So the first step is you've got to get this entity rated with the SEC. We've got to get the bonds rated. So we got to know what the structure is that we're asking rating agencies to rate. Those aren't necessarily, they're not strictly lockstep kind of decisions, like you don't do the rating And then when that's done, or you don't do the registration, then move the rate. You can do some of that on a joint timeline. And then you have to go out and talk to your investors. And we would envision doing some sort of road show or phone call meetings with investors. So, I mean, what we laid out in our schedule was, receipt of financing order in March, kind of being in the market late June, early July. So that, 4 months kind of time frame is really what we will need at a minimum from the time the financing order is issued. And so, I think there may be some ability. I mean, I think that would be up to the commission to put some time parameter on it. But I just want to lay that kind of time frame out, that if it were less than 6 months, it would be very difficult to ensure that we would be able to get to market in that time frame.
Some familiarity with the issuance process, so I understand that it cannot be too short. I understand that, but I really was asking more conceptually, would it impair your ability to go forward if there was a end date for the ability to exercise the financing order?
As I think about it, I can't think of a practical reason, but I guess I would have to defer to my legal counsel to say whether there's really a problem with that or not.
Okay, well, let's leave that then for now. I think we've explored that. I think most of the other questions I would have asked you would have been answered, or you've responded to them on others, but let me just be sure on one. I want to make sure I'm making an assumption you don't disagree with. And my assumption is that you would not choose a floating rate issue unless the all-in costs, including the cost of the swaps to hedge, was better, gave you better pricing than a fixed rate issue. I'm correct in making that assumption, right?
Yes,
yeah.
Certainly. But I also think that from my familiarity in the market, the floating rate issuance for what I think we agreed in our settlement for up to 20 years. I'm not sure you can have a floating rate product in the public markets for 20 years. But yeah, and conceptually, yeah, you would have to evaluate and analyze that floating rate with a swap back to fixed is more beneficial than the fixed rate you could get in the market. Absolutely.
That's fine. I did think of one other thing I wanted to just hear you talk a little bit about. Is the companies have elected in this round not to use the permission the statute gives to set up a reserve fund and to finance that reserve fund or to fund it out of proceeds from the securitization. And obviously, if you did set that up, you'd have a larger issue, and that might affect the terms, the structure, and the pricing, and so forth. I understand all that. But it also would give you some protection, give ratepayers some protection against pancaking in the future as we get hurricanes and storms going down the road. Talk to me a little bit about what considerations went into the companies thinking about why not to include a reserve component in this issue.
My understanding from talking with our regulatory folks back when we were drafting the petition was that we already have some level of kind of base storm recovery cost in base rates, and so we take this kind of deductible, we call it, every time we have storms up to that level before we start deferring anything for future recovery. So I think that kind of that normalized level in base rates kind of obviates the need for a reserve at this point.
That's a satisfactory response. I appreciate that. I just was curious to know if there was any other thinking going on behind why you chose not to use that authority. I think that covers it. Those are all the questions I have. Thank you, Mr. Heath.
Thank you.
All right, Commissioner Duffley.
Good morning, Mr. Heath. I'd like to follow up on some of Commissioner Clodfelter and Commissioner Brown-Bland's questions. And it has to do with the timing. And so is the current position of the companies to issue these bonds within the next year?
Yes, so our current proposal is that we, after receipt of a financing order, we put together a calendar that would get us into the market this year, within this calendar year.
And then hypothetically, if an uncompleted transaction scenario occurred, how long would you attempt the securitization process before turning back to the RADR, which hasn't been approved or disapproved, but going back to a traditional process?
It's hard to say, but I mean, I think we would have to think about it collectively with Treasury and our regulatory group, our attorneys, to figure out, how long we would do that. If we would try to go to market again. But I do think that if we tried to go in July and we didn't have a successful transaction, I mean, just the way I think about it today, I think it's really, later in the year before we would even try again.
And then my last question, I'm going to switch gears on you. Thank you for that answer. With respect to I understand the benefits of allowing flexibility, or what the benefits of allowing the flexibility regarding the structuring and pricing and marketing. But what, in your opinion, would be the pitfalls or negative aspects of the flexibility that you're requesting?
I mean, I guess it's some thought of loss of control, right? That you don't have clear insight into what we're thinking. But I think we propose to mitigate that through an issues advice letter process and potentially a bond team with the commission as a joint decision maker. So I think one or either of those approaches can help mitigate that concern.
Okay, thank you. I have no further questions.
All right, Commissioner Hughes.
No additional questions at this time.
Commissioner McKissick.
I have a couple of questions, Madam Chair. Mr. Heath, could you contrast and compare the advantages of going private placement route versus selling the bonds in a more traditional way?
Sure. I mean, and to make sure that I understand what you're asking in terms of private placement. So there's the kind of the private placement provision in the SEC registration documents versus this kind of negotiated, or not negotiated, but auction type deal I described in Florida. So I want to make sure I understand which one you're asking about there.
Well, I know that what you're asking for is authority, from what I gather, to go private placement route. And are you limiting it to simply the way the Florida does it, or are you looking at the way the SEC would do it? And I'm just trying to understand fully what it is that is being proposed as the model that we would embrace in North Carolina, and contrast that otherwise. Mm-hmm.
Okay. So what we're proposing is a fully negotiated, publicly registered and marketed deal to all investors that are out in the public market. Institutional investors, these are insurance companies, money managers, all those sorts of parties, where we go out and this deal is publicly announced, and we have underwriters who have list of investors that they go out and call upon to bring into this deal. And so that is kind of the broadest marketing you can do, is like you go out and reach out to everyone. If you are doing a private placement that's available under the SEC rules, you're talking with a much narrower audience of people, investors. And then if you're doing something like FP&L did, where you're doing this auction process with a group of banks, you're talking to an even smaller subset of people. So we believe that the fully registered and marketed approach will bring in the biggest, the broadest interest, which helps to drive pricing down.
Okay. Now, let me ask you this. Assuming there's a bond team and the bond team's in place, what role do you see them playing in terms of, say, coming up with, say, a marketing plan for the way that these bonds might be offered to potential investors?
Great question. So I want to again kind of preface my discussion about a bond team as being a bond team that has joint decision-making authority that is in the hands of the company and in the designated commissioner or member of commission staff, not in the hands of the public staff, an intervening party. And so we would say that bond team would then further have kind of advisory members, if you want to call it that, the underwriters, potentially the public staff and its consultants and others who can give feedback on different documents and approaches to things. So we would, our approach, similar to Florida, would be that we would ask the banks to put together a detailed marketing plan. How would they go out and talk to accounts? Who would they target, both on the short end of the maturity spectrum, you know, the 1, 2 to 3, 4, 5 years, and then the further out periods. And those will probably be very different investors. Different investors target short-term, different investors target long-term. And so we would want to understand that plan. And so this bond team would be looking at those plans that the underwriters put together. And that way, so if we come up with a bond team, that's what we've outlined in our rebuttal testimony, the underwriters would have put those plans together, the public staff and other parties on that team would comment on that. But ultimately, it would be the commission or the commission representative and the company representative who would decide, yep, this is the way we want to go to market, or we want to target some additional investors, or we don't think this plan is sufficient, or those kind of comments. Is that what you're looking for?
Sure. Yeah, that's exactly what I was looking for. And let me ask you this, in terms of the underwriters that are going to be involved, I take it they're going to be identifying benchmark or comparable securities that they would use to measure against in terms of what this particular offering would look like, you know, in terms of pricing and returns and things of that sort. So, I mean, to what extent do you see the underwriters operating somewhat autonomously as opposed to working with the bond team, and to what extent do you see, say, the commission playing as a part of that? I mean, if there's a disagreement or there's not a meeting of the minds.
Okay. So if they're, so the underwriters certainly would not be going off and doing their own thing, not by any stretch of the imagination. So their charge really in how do we approach the market would have to be signed off on by the joint decision makers. And again, that joint decision making authority needs to be with the company and with the designated commissioner or member of commission staff. And you brought up the point of underwriters developing pricing expectations, right? And looking at comparable securities. That is true to some extent, but also the company would have its opinion as well as to what those comparable securities are to make sure that the right comps are being used, right? That we're not looking at comping this to a utility first mortgage bond. This would be AAA rated debt. We're comping that to other AAA instruments and potentially U.S. government agency type debt. So we would have, active feedback, including with the commission as that joint decision-making member, on what do we believe are the right comps to use in this analysis before any conversations are had with investors. And if there were a dispute between those two joint decision makers, right, the company rep and the designated commissioner or commission staff, we would look for the full commission to resolve those.
Got it.
Commissioner McKissick, I'm going to interrupt you, sir, just for a minute here. We are at 12. We're a little bit after 12 at this point, so we're going to go ahead and take our break. And we will be in recess until 1:30. We'll resume with questions from Commissioner McKissick for the witness.
Thank you, Madam Chair.
All right, everybody, please turn off your cameras and mute your microphones.
Thank you. Thank you.
Good afternoon, Susan.
Hi, John.
How you doing today?
Not too bad. You need me to do anything or?
Nope, I'm just checking your audio and your video looks fine, so you are good to go. We should be starting hopefully in about 15 minutes.
Okay, sounds good. Thanks.
No problem.
Hello, John.
Afternoon, Mike.
Hey, how are you doing today?
Not too bad. How about yourself?
Pretty good. Don't think I'll get on today, but I thought I'd go ahead and do a check just in case.
Sure, no problem. No, your audio video sound good. You're good to go.
All right, thank you.
Sure, no problem.
Bye-bye.
Bye. If anybody wants to do a quick audio video check, now is the time to do it. Just turn on your video and I will call on you. Thanks. Commissioner Gray,
Hey, Mr. McCoy.
how you doing today?
I'm doing good. Sun shining in Winston-Salem. We got a little dusting of snow, but that was it.
Yeah, same with us. My kids enjoyed it this morning. A brief sledding adventure, and that was about it. But now, yeah, the sun is kind of poking out, and it's mostly melted.
Yeah, so take care. Thanks.
You too. Commissioner Hughes, you need an audio check, or are you good?
Hey, John, how's it sound?
Hey. Oh, sounds good. Yeah, you're good to go. Audio and your video is good too.
We can talk about. John, am I okay?
Yes, sir. Audio and video sound good. You're good to go, sir.
Thank you.
Sure.
Hi, John. Are my audio and video okay?
Commissioner, or yes, audio and video is good.
Thank you.
Sure.
This is Bill Grantmeyer. Can you hear me?
Bill, I can hear you. I do not see you though.
Okay. I was doing you a favor.
There you go. Yep. Audio and video is good. You're good to go.
Thank you.
Sure.
All right, John, just checking my mic.
Audio and video sound good. You're good to go.
Thank you.
Sure.
Also checking in with the court reporter. If you could, just let me know that you are ready to go.
Yeah, I'm ready whenever you are.
Okay, perfect. Thank you so much. All right, let's go back on the record, please. We will resume with questions for witness Heath by Commissioner McKissick.
Thank you, Madam Chair. Just before our break for lunch, we were discussing the structure of a bond team. And I guess the thing which I would like to get a clearer understanding of is how that bond team would be composed and the powers, whether the powers would be co-equal. It's my understanding that Duke doesn't have a problem with a bond team being established that would be composed of a commission member or designee, as well as the advisor, financial advisor to the commission. And the Duke would have their representative as well as an independent consultant as an advisor, and perhaps their counsel. Is that correct? Is that the way you're proposing it and the way you envision it?
Yes, Commissioner, that's pretty much it. So the decision-making authority would reside in the representative of the company and the commission, designated commissioner or member of commission staff as the two co-equal, and those would be equal decision-making, co-equal decision-making authority between those two. Anyone else there, the underwriters, the public staff, and others would be kind of advising or making suggestions and reviewing documentation that gets put together for the transaction, but decisions would reside with the company and the commission, the commissioner or member of commission staff.
And I guess the other follow-up would simply be, so those co-equal partners would be agreeing upon an underwriter or underwriters, as the case may be, in case there's more than one, the structure, the marketing, the pricing of the bonds, and all of those issues. Is that correct?
That is correct.
Okay. Now, let me ask you this. I gather down in Florida, there was a similar entity or bond team created, and I gather their public advocate group, I guess the Office of Public Counsel, participated in meetings, but they did not have a role in the decision making. Is that the way that worked?
That's exactly right. So the OPC, the Office of Public Counsel, was invited to attend and participate and contribute in bond team meetings, and they could review documents and offer suggestions, but they were not part of the decision-making authority. That's correct.
Now, it's my understanding also that Duke has even gone at this point to identifying some firms that might be used by the commission if they want to hire outside advisors. Is that correct?
We gave some suggestions of firms that we know participate as or have participated in the past or in current transactions as commission advisors. And so, yes, we laid those out in my rebuttal testimony. That's correct.
I know that Sabre has been working with the public staff, and likewise, I guess they work with the commission staff down in Florida as a financial advisor. But my understanding, they were not on the list of firms that you provided as recommended or those that might be appropriate to become involved as advisors here in North Carolina to the commission. Is that correct?
That's correct, but that is because they are already engaged in the advisory capacity or consultant capacity to the public staff. And so we would believe that if the commission were to hire a consultant or a advisor, that it should be someone that's independent of the parties that the public staff and the company have already hired.
Now, I know earlier there was the exhibit that was introduced, I guess involving statute 62-15, and they went down to, I guess, the paragraph number 12, where it talked about, what public staff involvement would be. And of course it says, when deemed necessary by the executive director in the interest of the using consumer consuming public, advise the commission with respect to the securities, regulations, and transactions pursuant to the provision of Article 8 of this chapter. With that language being in there, I guess in North Carolina, I mean, would you view the public staff still advising the commission on these issues, even though they would not have a formal role in decision making, and Sabre potentially being a consultant to them, separate and apart from a financial consultant that the commission might hire?
That's an interesting question. And quite honestly, I really haven't given any thought to, whether the public staff's advisor could also be the commission's advisor. That seems a little strange to me, and the fact that they would be advising both would seem, I'm not sure that's, where would their responsibilities to the commission versus the public staff reside? We have concerns with the public staff being a joint decision maker for a variety of reasons, but we see that role as being available to the commission as it's been done in other states because of the responsibilities and the obligation the commission has pursuant to the statute. And that would be things such as making findings of fact in the financing order and enabling the creation and transfer of the intangible property right to the SPE and enacting the true-up mechanism to make sure that enough cash and only enough cash is collected from customers to service the bonds, and then making the state pledge on behalf of the state to not impair that property right or disallow charges. And so those are clearly obligations and responsibilities of the commission. I do not see that the public staff directly participates in those things. So for me to say that I see a conflict there from the public staff advisor also playing the role of the commission advisor. That's why we would think that those would need to be separate parties. I don't think the commission would be comfortable hiring Guggenheim Securities, our advisor, as its advisor in this transaction. So I don't know that it would be appropriate or, for the commission to hire the public staff's advisor or to delegate that authority to the public staff.
I understand, and I guess I might not have stated my question clearly. The question was basically, do you see the public staff and their advisor, Sabre, let's say they remain the advisor to the public staff, being in a position to basically provide the commission or the commission designee with information as a member of the commission. And of course, it could be possible that the commission would have its own separate independent financial advisor, separate and apart from SABR. Would you see that potential to provide information, and maybe the word advisor is not the best choice, but to provide insight from their perspective to the commission? That's probably a better way of asking the question, would be appropriate or not.
Yeah, and I think we've kind of laid that out. We do see a role for the public staff and its consultants here, and it would be on the team, calling in, participating, and contributing to discussions of the bond team, and really advising and making comments to both the commission and the company on what they believe is the best route to go. And then it would be the commission designee and the company deciding whether the suggestion from the public staff and its consultant was the right course of action.
Let me shift gears a bit. In terms of potential underwriters, would you envision using one underwriter or multiple underwriters as a part of an issuance?
Certainly for a transaction this size, almost $1 billion, we think there should at least be two book running underwriters, and then probably a complement of maybe 4 to 6 co-managers who would be involved as well in actively selling the bonds.
You envision the possibility, I know we've talked earlier today about selling all the bonds at one time, but how about the idea of doing the bond in tranches of a certain magnitude that might, still stimulate and provide the type of interest that you would need and still provide the returns that everybody feel appropriate, but not necessarily issuing 100% of the time. Theoretically, I don't know what that number would be, but let's say it was decided that 50% might be issued and another 50% a separate tranche. Have you given thought to that, and has that been done in other jurisdictions?
I believe it has been done in other jurisdictions, and it is something I think we could consider here. We haven't put a lot of thought into it at this point, and primarily because I think it's my view, and I think a fairly consistent view of most issuers, is that the larger the transaction, the better. The larger a transaction, the better. So smaller transactions generally don't get as much attention from investors in a larger transaction. So a transaction, especially a combined transaction like we're asking for flexibility for here, of almost $1 billion, would get significant investor attention, we believe, and would have better execution than a $400 million and a $600 million issuance or something like that, right? And to kind of, I'm glad you asked that question, because I do want to come back to a discussion that we had before lunch about this idea of if you can sell 95% of the bonds, is that a good result or whatever? And our goal here, as we laid out in the financing application, is that we want to fund and recover 100% or the full amount of the storm recovery charges for both DEC and DEP. And yes, we could think about, two different ways of doing that. But, our point, a successful transaction in our mind is one that sells 100% of the bonds, and we give a certification to this commission that we, in fact, did achieve the lowest storm recovery charges that were available in the market at the date the bonds were priced and issued. And so that's a successful transaction to us. We could think about the idea whether it's 50% now, 50% later, but this idea of, can you fund 95% with these bonds and consider that a successful result? We're requesting here to fund 100% of the storm recovery cost. And for us, that's a successful result. Issuing bonds for 95% and then going back and trying to recover the other 5%. I think that's kind of what else in the storm recovery rider doesn't seem to make a whole lot of sense to us. So I know that went a little further than your question, but I hope I got your question answered in there as well.
appreciate your full, complete, and more expansive response. I think that provides clarity and context. Well, let me ask you this. In terms of marketing the bonds, I mean, do you intend to go beyond the traditional investors that would typically buy this type of bond product? I mean, how do you get and expand that market of potential investors? And has thought been given to how that might be done? So you're going beyond the traditional investors.
So, you know, a lot of these securitizations have been done on shorter recovery periods. So 7 year, 10 years, you know, and those attract, like I was saying earlier, that shorter duration attracts one type of investor. When we start going out 15 years, 20 years, you're really having to go out and go to investors that haven't invested in or haven't invested heavily in these utility securitization bonds. And so you really want to reach out to traditional corporate investors on those. And so that's why we want to structure and align this issuance so that we're really kind of portraying this as a corporate issuance rather than a structured finance or ABS, asset-backed security issuance. And so that gets you better execution, we believe. We saw that in Florida. And then in terms of, we want the broadest execution of this transaction as we possibly can get. And we believe that we were very successful at doing that in Florida, where, you know, we didn't just have the investors go to their typical large accounts. We encouraged and we really pushed them to go to kind of smaller investors that may not be putting in the $100 million or $50 million order, but investors that might be wanting only $10 million or $5 million of bonds. So that's one way. And then our other approach in Florida, which again, I mentioned a second ago, I think we want to try to replicate here as well, is to have these active co-managers involved. So a lot of times you have a co-manager involved and they aren't doing a whole lot of selling. And that's not our philosophy. It wasn't our philosophy in Florida, won't be our philosophy here. But we want co-managers who are actually going to be active and go out and market bonds. So we get into, you know, especially some of these minority or veteran or women-owned firms that are smaller. They're not your Goldman Sachs, they're not your Morgan Stanleys, but it's like Williams Capital or Drexel Hamilton or Ramirez and company. Those folks, they have relationships with much smaller kind of niche investors, and they can bring in, you know, investors who haven't maybe participated in these in mass in the past and probably maybe even don't get a chance to participate in corporate bonds in general. And they can bring those into these deals and drive some pricing competition.
I think it would be excellent if firms such as that might be considered, you know, potentially as this moves forward. Let me shift gears a little bit. Now, let me touch base on one thing you did say. You talked about the asset-based securities. In Florida, they didn't do asset-based. I mean, they did the ratepayer-backed securities the way we're talking about doing here, right?
So the asset-backed is it's kind of a class of investments in the broader public debt market. So you can think of these two big pools of being corporate bonds and then asset-backed securities. And some of these earlier utility bonds that were done a couple of decades ago may have been more seen as asset-backed securities. But that asset-backed nomenclature kind of gets people thinking of like issuances by credit card companies or issuance by automotive finance companies. And so those are much different than what we're dealing with here, right? You got to worry about FICO scores of those individual loan holders and all of those sorts of things. And there's default risk under these, you know, from individual accounts not being able to pay that get factored into that. And those kind of things get packaged as with a lot of reserves, right? You put in really larger amounts of loans than you really need to cover the servicing of that debt because of those people who are going to default, right? And we don't have that here. I mean, we have with this true up mechanism. Yeah, so that's why we think that it's important to look at these as more of a project type thing or a or a corporate bond and not an asset-backed security. And that's our plan here, is that we will not register these as asset-backed securities. So they will be on a registration statement called a form SF1, which does encompass asset-backed securities, but it will be clearly noted that these are corporate bonds and they've been registered as such by the SEC.
Just one or two follow-ups, and that's simply this. You talked about the certifications. Now, I gather the certifications you're speaking of would be something that would essentially state that the way things were handled was compliant with the general statutes that are set forth in the general statutes. To what extent, I gather public staff and Sabre has talked about certain best practices that might be utilized or followed. What do you see as the challenges or problems that would present in terms of certifications or in terms of other aspects of work that would be done related to these transactions, and more specifically, the way the bond team might address issues? He goes off.
Sorry about that. So these best practices, there's some that have been outlined in the public staff consultant's testimony, and there seems to be when at least when I read the testimony, it almost is worded as such that we haven't done those best practices, that we're not committed to doing those best practices, and that it is just not true. We have proposed that most of those best practices be implemented, and that they are in fact in our transaction documents that we are in the petition and in the transaction documents that we've put forth. And so things like the commission, following the statutory requirements, right? And we believe that. So certifications was one of them. You asked about certifications specifically. And so, I think their proposal is that you have certifications from, the company, the public staff consultant, the underwriters, and that has happened in other jurisdictions, including Florida. But I would point out that the certification that we are proposing to make here goes further than the certification that we, as an issuer, Duke Energy Florida, and the SPE there, made in Florida. So in Florida, that certification was effectively that the issuance of the bonds and the resulting storm recovery charge resulted in lower cost to customers than traditional regulatory recovery. What we're proposing to certify to here is that the structuring, marketing, and pricing of those bonds, and so I'll point structuring, marketing, and pricing. The statute only requires that we certify to the structuring and pricing of the bonds, but we are willing to certify to all three of those. That process and the resulting charge is the lowest storm recovery charge available in the market at the date we issue those bonds. So by taking that added step that we're certifying to the lowest cost standard, we don't believe that any other certification should be required in the commission's evaluation of whether you accept or reject the issuance advice letter. If other parties were to give a certificate, I'm not saying that you should ignore it or disregard it, but I think the only certification that should be a deciding factor in whether the issuance advice letter is accepted or approved should be the companies, because we are certifying, or we will certify, to the lowest cost standard.
This will probably be my last question unless something else comes to mind. Have you ever been involved in a situation where you've gone through all of what's required? The bonds are about ready to be issued, but I guess out in Texas they got this 2-day window where all the information comes back in, everybody goes back, reviews the data, they try to see if it's meeting the benchmarks, and if not, they can issue, I guess, an order that suspends the issuance at that time. Are you familiar with any jurisdiction where a decision has been made to suspend the bond issue at that time and to go back and to ground one, I guess, and begin to reevaluate whether the timing is right, the market or other circumstances are best to achieve the desired outcome with the bond issuance?
I'm not aware of that having happened anywhere. That's not to say that it hasn't, but as I think really quickly about the 66 transactions and that's been done in this space since the mid 1990s, nothing comes to mind where there was a stop order or a cancellation of a transaction on behalf of a commission.
Go ahead. I didn't mean to interrupt.
I say, if I could, I want to just to go back to that certification question. So this certification that we're giving here, we don't make that certification on any other debt issuance that we do at a utility, whether it's before this commission or any other commission. So that's something that's unique to these securitization bonds. And so I believe, the fact that the company is willing to put that certification in place, especially here in this transaction as a lowest cost standard, should give the commission great comfort that we are taking every effort possible to get the best execution on this deal that we can, because it's Duke's a Duke officer is going to be signing that certification saying we in fact got the best deal that was possible. And so I think that should alleviate a lot of concerns from the company. That's not a certification that we take lightly. And so I just want to clarify that.
The last follow-up would be that 2-day stop window to issue a stop order. That's what's being proposed in North Carolina as well. Is that correct?
It's 2 or 3 days. I don't remember
2 or 3
hands. So there's we would price the bonds. We would put that letter together and put it before the commission, and then there would be it's 2 or 3 days where the commission could act and say, yeah, we're good with this result, or we don't like this, and you got to put the brakes on this.
Thank you, Mr. Heath. Well, I don't have any further questions at this time. Madam Chair, one thing I will bring your attention, your video was flickering on my screen. I'm not sure if others were seeing that or not. Maybe it just be some interference I'm experiencing. Thank you.
All right, thank you, Commissioner McKissick. If y'all lose me, I'll do my best to get back on. It could be something with the internet service here in the building. Mr. Heath, I want to ask you a few questions, and I'll be brief. My colleagues have already covered ground I was going to cover with you, and you have been on the stand for a while now. So I want to move quickly through my questions so we can keep moving forward here. But Commissioner McKissick was asking you about the issuance advice letter process and the proposal that the commission have a period of time to issue a stop order. We'll just use the shorthand and refer to it as a stop order. So let's say just for the sake of having this discussion that the commission does in fact issue a stop order. So what would the company then do?
So that transaction would then not go forward, right? We would go to the underwriters and say, hey, we're not going to be able to issue these bonds. We have an order that prohibits us from doing so. We basically pull that deal out of the market, and then we have to figure out how do we go forward for recovery of those costs. And that could be, as I mentioned earlier to Commissioner, I forgot who it was early this morning, that could be a transaction later, another bond transaction later, or it could be that we may have to seek recovery in the storm recovery rider, if approved, that we've asked for in the rate cases.
So potentially you go through, if you do not opt to recover under the traditional method in a general rate case proceeding, you would go through, and the company elects to go through the securitization proceeding again, you would start all over, or help me understand sort of the company's understanding of the process at that point in time.
We talked this morning about whether there would be some end date to, some date we have to issue by that could be put into the financing order. And so, if there was no date there, I believe, and our attorneys could clarify, but I believe that financing order would still be valid, and we could then go, pull back rethink things, figure out how to correct whatever the issue was that the commission saw with that offering, and then go back into the market at a later date under the same financing order.
Okay. And I recognize, what the company would actually do in that circumstance would be dictated by the concerns that have been raised for the particular transaction. But I just want to understand the company's understanding or proposal of the process. So thank you for that. Thank you for that response. You do testify. I'm looking right now. I'm looking at your direct testimony. You don't need to pull it, but you testify that for each month of delay beyond, in your testimony, it says May 31st, but the targeted issuance date, the companies will continue to accrue carrying charges. And I believe it's company witness Abernathy that actually gives us specific numbers there. It's like $1 million for DEC and $4 million, I believe. I'm just going off my recollection for DEP. And you testify that any delays will result in higher accrued carrying charges and ultimately higher bond issuance amount. What would cause delays? First question for you. What would cause a delay? Why would there be a delay?
There really shouldn't be, but I mean, I think delays would be if, so we put forth in our petition that carrying charges through May, we were contemplating a early June issuance, correct? So we heard this morning that we've made an application to delay the receipt of the financing order for 30 days. So that's a 30-day delay right there. So that's going to add some additional dollars to the bond issuance amount. If we had a bond team and for whatever reason, those joint decision makers, again, that we're proposing being the company and the commission, if there were some dispute that we could not reach an agreement on, and then we had to come back to the full commission for some direction, that might add some time. Or just, lengthy debates amongst those co-decision makers as to the best course of action that could add some additional time. The SEC is going to take as long as they need to take in reviewing the registration statement. Our calendar is going to assume that's probably a 4 to 5 week process, I think, maybe 4 to 6 weeks. But they're under no obligation to act by a certain date that I can recall. So that could take longer. There's going to be a comment letter process back and forth. So the more comments they ask, the longer it takes for us to address those comments and such. Right. So if there's multiple rounds of comments, that could delay things. Once we get into the ratings process, the rating agencies, S&P, Moody's, Fitch, they all understand this asset class very well, even though there are infrequent issuances of these bonds, but they understand the assets very well. And so I don't really foresee what could cause delays with the ratings process. And then you really just get into what's the right time to get into the market from there.
Okay. All right. That's helpful to my understanding. I appreciate it. All right. I am, that's all I have. We will now take questions on commissioners' questions. We'll start with SIGFR.
Thank you, Chair Mitchell. SIGFR does not have any questions for this witness.
Okay. Public staff?
Yes. Thank you. Thank you, Chairman. Sure, I turned this up. I'm sorry. Mr. Heath, thank you. I know it's been a long day. Just wanted to follow up on any number of questions that you received from the commissioners. As a preliminary matter, I just wanted to ask you your view, the company's view, on when the commission's and the public staff's interest in achieving the lowest cost for the ratepayers would diverge. At what point in time would those interests diverge after the issuance of the financing order?
Are you looking at a point in time or like a theoretical under?
Whichever you prefer. I'm just looking for some clarity. Yeah.
Yeah. So, what we're proposing here, what I laid out in my rebuttal, is that we see, if there's a bond team that the commission wants to implement, we see that should be the commission or a designated commissioner or member of commission staff and the company as decision makers, and the public staff participating in all bond team meetings and calls, and looking at all documents. So I don't see that there's really any break there. I think the commission is tasked with looking at both the interest of the customer as well as making sure that the utilities are financially viable and stable. So I see that the commission has that added role, right? Customer interest as well as company interest, and got to balance the two, where I see public staff as strictly a consumer advocate.
Okay, thank you. And on that point, relating to ratepayer advocate, you've indicated about the certification that the company would be providing or willing to provide. In this instance, two kind of clarifying. Well, one clarification is, would that be a lowest in fact standard certification? Is that, I couldn't, it sounded like that's what you may have been saying just now, but I wanted to clarify that.
Well, it's what I read in the statute, right? That the issuance of the bonds and the resulting storm cost charge achieves the lowest cost to the customers.
All right, and then in terms,
I'm probably misstating. I'm probably misstating it. So it's that the issuance of the bond, the structuring, marketing, and pricing of the bonds, and the resulting storm securitization charge results in the lowest cost to customers.
All right, and then in terms of certifications, you were discussing from whom the commission should decide to receive them, but wouldn't it be beneficial to the commission and to the ratepayers to receive notwithstanding receiving a certification from the company to whatever degree, wouldn't it be beneficial again to the commission, to the ratepayers, to receive the certification from an independent or even a ratepayer advocate, or a independent advisor like the public staff's consultants in this instance?
I think what I said earlier was that I don't think the commission should ignore one of those if someone were to deliver one to them. But, I think that the fact that the company who makes no certification about its debt issuance cost for its utilities is in fact going to certify to the lowest storm recovery charges available in the market on the day we price the bonds is adequate.
Very good. And to be fair, just in this instance, obviously, one reason you don't normally provide those certifications is because, unlike a traditional issuance, in this instance, these bonds are effectively being paid back by the ratepayer.
All of our debt cost is paid for by our customers, whether they're securitization bonds or whether they're first mortgage bonds at the utility.
All right, we've covered that ground before today. So, two other areas, if we could. One goes to the whole issue that several of the commissioners right off the bat got to, and it's selling, 100% of the bonds, market pricing. In this transaction, just to be clear, the lead underwriter or the book running underwriter will receive a fee or commission for selling the bonds in this instance. Isn't that correct?
All of our underwriters, right, will receive some compensation for their efforts or for selling the bonds.
Right, and then you have, as part of your Exhibit 1, you've estimated that the fee that the underwriter will receive in this instance is, I think, approximately about 0.5%, which is maybe $3.9, about $4 to $5 million, given what we know now. It's estimated.
Yeah, so I put in there about 40 to 50 basis points. I kind of gave a range there.
Right.
So that's in the number of, 3.9 to 4.9 or so.
All right. And sometimes, like in the DEF Florida transaction, the issuer of the bonds, and here the issue would be, I guess, the SBEs of the utilities, require that the lead underwriter accept some of the risk in the transaction. In other words, have some skin in the game. Isn't that correct?
Yeah, that's true. And I think those are all, that would be based on facts and circumstances decision on an individual transaction. So, we were talking about earlier this, could we sell 95% versus 100% or whatever. And so, yeah, I mean, I think we would have to look at the totality of what happened in the transaction and decide, whether or not we want to push those underwriters to take bonds to clear the transaction.
Okay. And for the ratepayers, obviously, having the lead underwriter take on some risk, presumably is a good thing because it means that they have a stake in the transaction. They're going to get paid regardless, basically. I mean, if the transaction goes through, will it not?
They're going to get paid if the bonds are issued.
Okay. And continuing on that point, I did want to briefly, if I can, Chair Mitchell, point to a pre-marked exhibit 28 that is the various exhibits to witness Fischera's testimony. That's on page 448 of the consolidated pre-marked exhibits, page 448, and this is pre-marked exhibit 28. If I've got that correct, let me make sure I've got that right. Let's see here.
Yeah, I'm looking at pre-marked exhibit 28, and it starts out with Mr. Fischera's bio or resume.
Right, and I misspoke. It's 1448. That's why I was looking at my numbers here. It's page 1448. I'm so sorry.
1444, actually.
Okay.
But
right.
Regardless, we're looking at the document we're looking at as some sort of CV or list.
That's right. And my apologies. I'd like to, yes. And so I would please, I would like to, and I'm planning on scrolling down to page 1448. But I'm pleased to, I'd like to enter this as public staff Heath cross-examination exhibit 4. I believe that's correct.
Chair Mitchell, this is Jim Jeffries. I may have missed an exhibit there, but I thought we were on cross exhibit 3.
That may be correct. Let's see here. I've got my list here. My apologies.
One were the statutes, 2 were the.
Right. We're on 3.
Very good. Very good. My apologies. Thank you, Mr. Jefferson.
All right, so we will identify the document. We will mark the document as public staff Heath cross-examination exhibit number 3.
Thank you. Thank you, Chair. And if you could scroll down, please, Mr. Heath, to page 1448. Which says order book status. And again, obviously this is discussed in witness Fischera's testimony, but this is a Credit Suisse order book status, correct?
That's what it appears to be, yes. But yeah, it doesn't say what transaction it's related to, but that's what it appears to be, yes.
All right. And if you look on, if you go down, these are different tranches. Tranche 1, 2, 3, 4, and 5. And you see on the right hand side the percent subscribed, starting at 121% for the first tranche, 118, 112, 96, and 131.
Correct.
Okay. And just kind of going back to our prior point, this is a transaction that went through with all the tranches but one oversubscribed by a good deal, it appears. And in this transaction, I would, in the present North Carolina transaction, is it the company's contention that even if other tranches are oversubscribed, that the storm securitization transaction in North Carolina issuance would not go forward unless and until all the tranches are fully subscribed?
Not necessarily. I mean, again, it would depend on the dynamics of the book and the deal in total. And so when we were talking about 95% versus 100% earlier, I think my comments were really thinking about of the total deal, not of an individual tranche. I mean, this is so 96% of a $68 million out of a roughly $400 million transaction wasn't fully subscribed. I would think that, in that case, again, not even knowing what deal this relates to and not being intimately involved in that deal, I can't comment on specifics, but I would say, that is a much bigger, much more different scenario than 95% of the total deal not being subscribed, not being right.
Right. And just finally on that particular point, in a particular transaction where several percentage points, percentage of bonds are not, there are no orders for them yet, the lead underwriter would take the risk of those bonds, correct? I mean, they would take ownership of the bonds and then have to resell them. Is that the way that would work?
Can you go through that whole scenario again?
Well, I guess it's my understanding that obviously underwriters actually technically all purchase the bonds and then they're resold based upon orders. In this instance, if several percentage points in North Carolina they're not orders for those, the underwriter would hold them, and it behooved the underwriter, including based upon the fee that they're receiving and they have a stake in the process, to sell those bonds.
They might. It depends on what's significant, how much we're talking about here, right? I mean, if we're talking about half the deal, I don't see that playing out that way. If we're talking about a couple percentage points, it's very possible.
Okay, we've covered this. Thanks for your patience on that particular topic then. One more, if we may. In some of the questions today, including from Commissioner Clodfelter, there was discussion about the Commission's broad authority generally and within the securitization statute, including subsection 12 that allows, quote, any other conditions not otherwise inconsistent with this section that the Commission determines are appropriate. And you stated that you were involved in the DEF Florida transaction, and you may be aware, or are you aware, that in the state of Florida has kind of the same language in its statute, and that the Commission there went on nonetheless in its financing order to require a lowest charge standard. Is that correct?
That is correct. But I would point out that Commission, the Commission does have broad-based authority, and there is a provision there that they can impose other conditions in the transaction that aren't inconsistent with it. I think it's really an interpretation as to, what to the extent of what those conditions can be, right? I mean, the commissions in each state operate differently from one another to some extent. The statutes that enable commissions that give the commissions their authority or have different language. And so I don't know that you can necessarily say, well,
the Florida Commission or the Texas Commission or the California Commission did X, Y, and Z, so the North Carolina Commission should do X, Y, and Z as well.
Okay. And with respect to those two items, I would like to place in the record, if I may, Chair Mitchell, pre-marked public staff exhibits 2 and 3, which are Florida statutes and the Florida DEF financing order.
Chair Mitchell, could I have just a moment to take a look at those real quick?
You may, Mr. Preach.
Yes.
Just so I'm clear, are you at this time seeking to have marked for identification public staff cross-examination exhibits 2 and 3?
There would be 4 and
right.
4 and 5.
Pre-marked 2 and 3.
Correct. Yes.
Is that what
Pre-marked
you're
2 and 3.
All right. So let's go ahead and mark them then. We'll mark this public staff cross-examination, assuming Mr. Jeffries that you don't have an objection. Public staff keeping cross-examination exhibit number 4.
Chair Mitchell, it's not clear to me. Mr. Creech, do you intend to ask Mr. Heath any questions about these?
I was hoping to get them in, but we can move on. I think we may have covered that. I think it's a little bit of a hurdle here today, I think. And
yeah, I don't think there's any formal objection for awkwardness in the process. But,
all right.
I was going to suggest that maybe since these are public documents, that the commission could take administrative notice of them if you
that would be
use
great.
them in a brief.
Yes, that would be great. If that's
all right. Why don't you make a motion for the commission to take notice of this document? So I understand specifically the statute you want us to take notice of.
Yes, I would. Thank you, Chair Mitchell. I would like to ask that the commission take administrative notice of the Florida statute in pre-marked 2, which begins on page 22 of the consolidated exhibits provided to the commission, and also pre-marked 3, which is the financing order for Florida Power and Light Company. Excuse me, I misstated that. Excuse me, for Florida Power and Light Company on page 55 of the combined exhibits.
All right, the commission will take judicial notice of the Florida statutes as well as the order of the Florida Public Service Commission issued May 30th, 2006 and docket 060038-EI.
Chair Mitchell, this is Kamal Robinson. Oh, I'm sorry.
Robinson, just hang on one second here. Mr. Creech, I'd like for you to find at some point, perhaps on our first break, on our next break, the full citation to the Florida statute that you want us to notice, just so the record is clear.
I do. Thank you. And those are all my questions.
Okay. So, Mr. Robinson, I see that you want to be heard, but we are now with you on Mr. Jeffries on the commission. Mr. Robinson, you may proceed.
Yeah, Chair Mitchell, thank you. I just have just a logistics question. I know we're going to be moving along with some of these exhibits, and I think it might be an appropriate time to maybe just get some clarity on a few things. Mr. Karan Mehta is not in this case, so I think it's probably me to be the exhibits police. this time around. But an example, so public staff, Heath, cross-examination exhibit 3, and I think 2 as well. They are, I believe, exhibits to testimony. And my question more so is, if they are marked in this docket as cross-examination exhibits, and they're also exhibits to testimony, what is the appropriate nomenclature that you'd like us to use, say, for briefs and things of that nature? It's just more of a clarity question as to which one would you prefer control?
Well, ideally, we don't have them in the record. We don't have them in the record multiple times. So if we could work to avoid that, that would be ideal. But since we've already got these in the record now multiple times, let's refer to the cross-examination exhibit nomenclature, or the nomenclature that we're assigning during the hearing.
Thank you, Chairman.
That I think just keeps the record the clearest. I mean, you all can argue with me otherwise, but that's my preference at this point in time, hearing nothing else from you all. Okay. Okay. All right. Anything else?
So Chair Mitchell, I have a couple of questions for Mr. Heath.
All right. You may proceed.
Thank you. Mr. Heath, do you recall some questions? And I apologize, I don't remember exactly who asked them to you, but one of the commissioners asked you some questions about the decision not to include a storm reserve request in this proceeding. You recall that?
Yes, I do.
Ms. Abernathy is coming up later on, well, hopefully later on today. Would she be in a position to also testify about the rationale behind the storm reserve decision?
Yes, yes, you would.
Okay, thanks. So at my peril, I'm going to return to the subject of certification again. As I understood your testimony earlier today, you said that the company intends to certify that the transactions at the time they close are consistent with the statutory lowest cost requirement. Is that correct?
That is correct.
And you've also indicated that you didn't necessarily see the value in it, but if other parties wanted to so certify as well, and if the commission found that to be useful, you didn't have any objection to the submission of those certifications. Is that correct?
That's correct. I don't have an objection to the submission of those. I don't know that they add much for the transaction, but I do think that only the company's certification should be the ones that determine, or that the commission is using to determine whether or not to approve the transaction.
And at least as I understand the public staff's testimony, public staff's consultant's testimony on this point, one of the arguments they make is that in order to provide a certification, they need to conduct independent due diligence of whatever the deal terms are that the bond team agrees to. Are you equally as unconcerned about that proposal?
No, I'm very concerned about that proposal of anyone speaking to investors in this transaction other than the companies and potentially the commission with respect to obligations, right? The findings of facts, the creating of the property, the enactment of the charges, and the state pledge. I mean, all those things are fair game for the commission to be in rating agency discussions and investor meetings commenting on. But, I don't believe that any other party should be speaking to investors outside the company and the commission, and of course the underwriters.
Can you explain why? I mean, what's your concern?
The biggest one would be with law and contractual law liabilities, right? The companies as the issuer, so the company, the SPEs as issuers and co-registrants, and the underwriters are the only two parties that will bear any sort of securities law liability in this transaction, not the public staff, not even the commission. But we do, but like I said earlier, we believe there's there's ability for the commission to be involved. We don't think, though, that the public staff can be that involved because of the, there may be loss of consistency of message. There may be things that are said in a setting with an investor that we maybe are not aware of, especially if those discussions are done on a unilateral basis. And if I don't know what has been said, I don't know what liability is being created.
Are you concerned that it might potentially have any impact on the actual ability to conduct the deal?
Absolutely. I think there's a potential that investors could be confused, right? Investors in these transactions have become somewhat accustomed to seeing the commission representative at the table and having discussions with them on particular aspects of a deal, but to introduce an intervening party like the public staff could create unnecessary confusion and detract from the deal.
All right, I have one more question, and it also relates to the certificate process to be provided by the company. And I want to be real clear on this because I think there's some confusion in the record in it. But as you read the statute 62-172, and I think it's subsection B3 that requires this certification or this finding by the commission, that obligation to reach that finding by the statute anticipates that finding will be reached in the financing order. Do you agree with that? That's your understanding?
Correct.
Okay. Now, the certification you're talking about is going to occur much later in the process. That if we use Mr. Creech's example, the certification, the financing order is going to take place in step one. And then this certification you're providing is going to be at the end of the process, right? So
correct.
All right. So, and is it going to be conditional? The financing order obligation says, it's got to be reasonably calculated and, subject to market conditions. And I guess your ultimate certification will be subject to market conditions in reality and practice. But I mean, is it going to be a certification that you've undertaken reasonable efforts to find the best cost, or is it going to be or the lowest cost, or are you just going to certify that it's the lowest cost?
It is a certification, the lowest cost being achieved.
Okay, that's all the questions I had, Chairman.
All right, with that, I will entertain motions from council.
Thank you, Chair Mitchell. The companies would move that Mr. Heath's pre-filed direct and pre-filed rebuttal exhibits be entered into evidence as previously identified.
All right, hearing no objection, Mr. Jeffries, your motion's allowed.
And Chair Mitchell, the companies would like to reserve their right to recall Mr. Heath at the appropriate time in the event that we feel like something else comes up in the interim that needs to be addressed by him.
All right, we will allow that. Is that all from you, Mr. Jeffries?
That is, Chair Mitchell.
All right, Mr. Creech.
Yes, I'd like to move in public staff Heath cross-examination exhibits 1 through 5.
All right, Mr. Creech, I have 3 exhibits for you. We've taken notice of the.
Excuse me, that's correct. That's correct. Okay. You've taken notice of the final 2, 1 through 3.
Okay. I'm sorry. I didn't hear what the chair said. There seems to be interference when you're talking.
All right, Mr. Creech, just for purposes of the record, make your motion one more time.
Yes, I would like to move into the record public staff Heath cross-examination exhibits 1, 2, 3, 1-3, 1, 2, and 3.
Okay.
No objection, Chair Mitchell.
All right, thank you, Mr. Jeffries. Mr. Creech, your motion is allowed. All right, Mr. Heath, you may step down, but you are subject to being recalled. Thank you, sir.
Thank you. Understand. Thank you.
All right, Duke, you may call your next witness.
Chair Mitchell, I know it's, this is Kamal Robinson. I know it's 2:30, and I also do know that there were some complications with hearing schedules and witnesses availability tomorrow. Would it be possible to maybe just have 2 minutes to just confer with counsel and potentially Mr. Creech or Mr. Grantmeyer? Maybe we need to touch base briefly to see if we call our next witness or if we allow witness Klein to step in front.
All right. I'll Mr. Robinson, let's take a recess of 5 minutes. Will that give you all time?
Yes.
All right, let's go. Let's recess and we'll be back on at about, let's say 2:40.
Thank you. Thank you, Chair Mitchell.
Thank you.
All right, Susan, let me know when you're ready to go back on the record.
Yep, I'm ready whenever.
Okay, perfect. All right, it's 2:40, so let's go back on the record, please. Mr. Robinson?
Yes, Chair Mitchell. The council has conferred, and Ms. Klein is able to go ahead of Mr. Atkins.
All right, thank you, Ms. Robinson. So we will hear from public staff witness Klein, and then we will resume with the company's presentation of its case. All right, Mr. Grantmeyer, Mr. Creech, you may call your witness.
Yes, Ms. Klein will be Bill Grantmeyer's witness, and I do want to thank Duke for being so gracious to accommodate us. Thank you.
All right, let me have her affirm before you begin with her, Mr. Grantmeyer. All right, Ms. Klein, raise your right hand, please, ma'am. You affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth.
I do.
All right, thank you. All right, Mr. Grantmeyer, you may proceed.
Please state your name and your business address.
Rebecca Klein, 40 North Interstate Highway 35, Suite 11-3, Austin, Texas 78701.
And you are affiliated with Sabre Partners, and you're testifying on behalf of the public staff today?
I am.
And did you cause to be pre-filed in this case 35 pages of direct testimony and 4 exhibits?
Yes.
If I were to ask you those same questions again today as to your direct testimony, would your answers be the same?
Yes.
And Madam Chair, the public staff asked that her testimony be copied into the record as if given orally, and the 4 exhibits be identified.
All right, hearing no objection, Mr. Grantmeyer, to your motion, the pre-filed testimony of public staff witness Klein shall be copied into the record as if delivered orally from the stand. The exhibits to that testimony will be identified as they were when pre-filed.
Have you prepared a summary of your testimony?
I have.
Will you please read that into the record?
Yes. Chair Mitchell and Commissioners, it's a pleasure and an honor to be here before you today. The summary of my testimony is as follows. Utility customers have the potential to realize meaningful savings if specific actions, practices, and processes are undertaken through the life cycle of stages of a ratepayer-backed bond program. The North Carolina General Statute contemplates a lowest storm recovery charge standard very similar to the statutory provisions in Texas. Adherence to the lowest cost standard results in benefits to the ratepayer at no cost to the utility. Texas completed 3 ratepayer-backed bond transactions during my tenure as a commissioner of the Public Utility Commission of Texas for approximately $2.5 billion. These transactions established the baseline for the program. The practices that we undertook resulted in an average ratepayer savings for the 3 transactions of $23 million nominal dollars and $17 million net present value, as compared to the pricing of other ratepayer-backed bonds during the same time frame. The actions and processes were developed and implemented that resulted in these bonds may be beneficial to the North Carolina Utilities Commission. In this spirit, I offer highlights below of the actions undertaken in Texas that resulted in a superior outcome in terms of transaction cost savings to ratepayers. Ensuring ratepayer interests are represented at every stage of the transaction. The PUC in Texas took an approach of being actively engaged in implementing the terms, conditions, and provisions of each phase of the transaction process. In other words, the structuring of the bond, the marketing of the bond, and the pricing of the bond. To engage the utility, the underwriters, and investors effectively, the PUC of Texas was supported by the special expertise of its financial advisor. This allowed the Commission to receive timely information and make decisions in real time on particular matters. For example, the Public Utility Commission in Texas noticed a hearing within 2 business days after pricing for the purpose of considering whether to issue a stop order if the commission was not convinced that the lowest transition bond charge objective, in fact, had been achieved. The Public Utility Commission of Texas reviewed the marketing and pricing information in real time so that the PUCT's hands would not be tied as a practical matter. This enabled the commission to have a framework in which to make decisions on pricing optimally in a timely way. Ex post information not satisfactory. In Texas, the PUCT was a joint decision maker with the sponsoring utility in all matters relating to the structuring, marketing, and pricing of the transition bonds. We expect the utility to work in a collaborative basis with the PUCT staff, as well as with the PUCT's independent financial advisor, to help ensure a successful transaction at the lowest transition bond charges to ratepayers. There is no reason why ratepayer interests and the utility's interests cannot be aligned in light of the fact that any savings that could benefit ratepayers do not affect what the utilities will receive as part of the securitization amount necessary to recover storm damage costs on behalf of the utility's ratepayers. On the other hand, the interests of underwriters and investors are not aligned with the ratepayers, and therefore it is imperative that the ratepayers' interest at the negotiating table. Codifying certain provisions in the financing order. The statutory requirements in Texas provided that the structuring and pricing of transition bonds result in the lowest transition bond charges consistent with market conditions. The PUCT went an extra step to require in its financing order that the marketing of the bonds also be incorporated. North Carolina has a statutory provision, NC General Statute Section 62-172B3B, which directs the North Carolina Utilities Commission, similar to the Texas Commission, to include in its financing orders any other conditions not otherwise consistent with this section that the Commission determines are appropriate. Given this authority, the PUCT felt that it was important to insert, quote, marketing, unquote, as a function of lowering transition bond charges because the manner in which the bonds would be marketed would have a strong impact on pricing and ensure lower transition bond charges. The financing orders in Texas directed the financial advisor to be actively engaged throughout the transaction process in order to ensure the greatest opportunity to meet a lowest cost transaction standard. Examples of the proactive initiatives the independent financial advisor undertook to help us reach our lowest transition charge mandate include: 1, insisting that any servicing fees and administration fees in excess of actual incremental costs be rebated or credited to ratepayers. 2, identifying any potential conflicts that may arise between the utility, the underwriter, and the utility's advisor. 3, participating fully and in advance in all aspects of structuring, marketing, and pricing the transition bonds. 4, challenging any decision it believes might not result in lowest transition bond charges to ratepayers. And 5, requiring certifications from the companies, the book running underwriters, and the PUCT's financial advisor that the structuring, marketing, and pricing of the transition bonds in fact resulted in the lowest bond charges consistent with market conditions at the time the transaction priced and the terms of the financing order. Although the financial advisor, Sabre Partners, in this instance is not supporting the commission, the advisor is supporting public staff who represents ratepayers. Similarly, the financial advisor in Texas lent its expertise to the PUCT, given that that agency had purview to protect customers of electric services consistent with the public interest. The Texas financing orders also required the utility to file a detailed set of analysis and representations called an issuance advice letter, see Klein Exhibit 1, about the pricing of the bonds and documenting the benefits of the transaction to ratepayers. Unity of purpose. There is no reason why the utilities, the underwriters, the commission, and the interests of the ratepayers cannot have a unity of purpose in striving to reach a lowest storm recovery charge standard. Any savings that inure to ratepayers materializing from an efficient ratepayer-backed bond program do not diminish the securitized costs that the commission determines is required for storm reparations. Therefore, utility and ratepayer interests are not inherently in disharmony. Chance of a collaborative and collegial process rests on the commission clarifying that the ultimate decision-making authority for all aspects of structuring, marketing, and pricing the proposed bonds rests with the designated member of the commission. In addition, the commission should be clearly dedicated to having the day-to-day decision-making rest with an ensemble that includes designated commission staff, the public staff and its respective financial advisors, and the utilities. As a collaborative, this group would represent the voices of all interested parties and can together help achieve the lowest storm recovery charge mandate through robust and transparent negotiation. This completes my summary.
The witness is available for cross-examination.
Chair Mitchell, this is Jim Jeffries. I will be cross-examining Ms. Klein today. Good afternoon, Ms. Klein.
Good afternoon.
I want to congratulate you on a varied and impressive resume. I don't know whether to call you lieutenant colonel or counselor or I'm not sure what's next, but I do have a few questions for you. I don't think anything will be too complicated. I just want to focus on a couple of points of your testimony. And I'd like to start off with the discussion of the statutory lowest cost requirement in North Carolina and your testimony about what standard the commission should apply here. So in your testimony, and I'm referring to page 6, line 5, if my notes are right, you suggest that the commission should adopt a lowest storm recovery charge standard when providing for the issuance of storm recovery bonds in this proceeding. Is that right?
Correct.
And I presume that you are familiar with North Carolina General Statute 62-172, which is the statute that authorizes the securitization transactions we're about today?
Yes.
Okay. And we're probably going to make reference to that. So, Chair Mitchell, I'd ask that DEC DEP, what's been pre-marked as DEC DEP cross exhibit number 1, be marked for identification, please.
All right, Mr. Jeffries, to the extent that you are asking, that you're referencing the statutory provision, the commission will take judicial notice of 62-172.
I am perfectly happy with that, and this document is already in the record in any event as public staff cross exhibit number 1, or as part of public staff cross exhibit Heath cross examination exhibit number 1. I'm just mostly concerned that Ms. Klein has a copy of it available to her.
Understood. All right, Ms. Klein, do you have the document available for reference as Mr. Jeffries asks you questions?
I do.
Okay. Okay, great. So this is, as I mentioned, this is the statute that authorizes storm securitization. And that statute in section B3, I believe, which is on page 5 of 14, at least on my version, that section requires that this commission find in its financing order that the storm recovery bonds, that the structuring and pricing of the storm recovery bonds are reasonably expected to result in the lowest storm recovery charges consistent with market conditions at the time the storm recovery bonds are priced and the terms set forth in such financing order. You see that?
I do.
Okay. And I wanted to focus on the fact that the requirement there, the statutory requirement anyway, is for the commission to find this as part of their financing order. You agree with that?
Yes.
Okay. Were you listening a little earlier when I was talking to Mr. Heath in response to some of the commission questions?
Yes.
Okay. Did you hear Mr. Heath say that the company's intent was to certify that the structuring and pricing of bonds are will result in the lowest storm recovery charges consistent with market conditions at the time they are issued?
Yes.
Okay. And that's essentially what you've asked the commission to adopt here, right? That's standard? That at the time the bonds are issued, that they're the lowest charges possible?
Well, I also heard the clarification about certification before and after.
I'm sorry, what are you referring to?
Certifications that all actions have been taken in order to reach the lowest storm recovery. So
You're saying that was Mr. Heath's testimony?
that's what I understood, that the conversation was that there was in the financial order, but then there was also certification after.
Right. There's a required commission finding in the financing order, and then Mr. Heath was specifically referencing the fact that the company intends to give essentially the same assurance to the commission at the time the bonds are issued. And I guess my question is, it seems to me that the answer is yes, but I'd like to hear your answer. Is that what you are recommending the commission adopt, that certification at the time the bonds are issued?
I'm recommending that the commission adopt language that the certifications are made by not just the utility, but also by the financial advisor and the underwriters.
Okay, thank you for that clarification. Ms. Klein, while you were a member of the PUCT, you were involved in 3 bond approvals, which you found to be similar to storm recovery bonds. Is that right?
That's correct.
Okay. And these transactions occurred in the 2001 to 2004 timeframe. Is that right?
Yes, that's correct.
And the commission hired a consultant to assist in those bond offerings, correct?
Correct.
And that consultant worked for the commission and was the commission's representative in the bond offering processes, right?
Yes.
Okay, and then as part of your testimony, you provided several of the financing orders that were issued by the Texas Commission in those transactions, and you had certain language in those orders highlighted. Is that right?
That's correct.
And was the highlighting intended to indicate those provisions that you consider to be best practices for issuing ratepayer-backed bonds?
Yes.
Okay. Now, at the time that these three bond transactions, you were a member of the PUCT. Is that right? And I'm sorry, you may have actually been chair. I didn't mean to demote you there.
Yes. A part of the time I was commissioner and part of the time I was chairman.
Okay, great. But now, shortly after that, you, if I understand your resume, you went to work as a consultant to Sabre. Is that correct?
I was an advisor, as I still am.
Okay, so you're independent. You're not an employee, but you do things like you're doing today for Sabre capacity as an advisor. Is that right?
Yes, on occasion.
Okay, great. On page 9 of your testimony, you state that the normal incentives to minimize waste and eliminate inefficiencies that are inherent in traditional bond issuances are absent with ratepayer-backed bonds. Is that right?
Yes.
Okay. But then on page 18 of your testimony, on lines 17 through 21, you also say, and I believe I heard you say this in your summary today, that there is no reason why ratepayer interests and companies' interests cannot be aligned in light of the fact that any savings that could benefit ratepayers do not affect the amount the utilities will receive as part of the securitized amount.
That's right.
You agree with that statement? You still agree with it?
I do.
Okay, great. Thank you. You also, in your summary, recommended that there be active participation in, I guess if you were listening earlier today, it would be phases 2 and 3 of Mr. Creech's example, but I'll refer to it as simply as the structuring, marketing, and pricing of the ratepayer-backed bonds, and that you felt it was important that there be someone representing ratepayer interests in that process. Is that right?
Correct.
Okay. So let's talk about that construct. Would you agree with me that 62-172, NC General Statute 62-172, does not contain any express direction for the commission or the public staff to actively participate in the bond issuance process after the issuance of the financing order?
That's correct. As it reads now, although it does provide a provision, a catch-all provision that allows the commission to insert any other condition.
Right. I'm sorry, go ahead.
As long as it's consistent with the securitization statute.
Right. But my point is that the statute is, I understand the argument that subsection B12 authorizes the commission to take actions that are not inconsistent with the statute, but you would agree that the statute is silent on public staff or commission participation after the financing order, right?
Correct.
Okay. If the commission determines to take the company's suggestion that was made in its rebuttal testimony to create a bond team where the commission was a co-equal decision maker on the bond team and was able to look out for ratepayers' interests and observe the structuring, marketing, pricing process, that would be consistent with your recommendations in your testimony, right?
If the full import of ratepayer interest were then yes, it would be. And that would include incorporating some of the recommendations that we have encouraged in this in my testament.
Right. What you're saying is, I think, is that you agree with me, but you also have all made some other proposals that I'll characterize as the details about the structuring, marketing, pricing process, and you would think those would be appropriate to include. Is that what you're saying?
Yes, that full ratepayer representation would reflect itself in incorporating the suggestions that I indicate in my testimony and the other witnesses.
Okay, all right, thank you. And you, of course, have heard Mr. Heath say that they're fine with the mechanism where the commission is a co-equal decision maker, member of the bond team. You heard Mr. Heath say that?
I did.
Okay. And you also heard Mr. Heath say that the company didn't have a problem if the public staff was an advisor to that process, and that the public staff's consultants were an advisor to that process, that where they drew the line, what was sort of the difficulty they were struggling with was carrying the public staff across the line to the status of being a co-equal decision maker, right? That's the hang up.
That's the hang up, and also interaction with third parties.
Yeah. Thank you for reminding me of that. So on page 23 of your testimony, you cite to North Carolina General Statute 6215 as support for the idea that the public staff should be included on the bond team.
Yes.
Do you have a copy of that statute handy?
I can get it.
Let me know when you got it, please.
Okay, I have it.
You ready? Okay, great. Subsection D of 6215 is describes the duties and responsibilities of the public staff, correct?
Correct.
Okay, and then there's 12 subsections under section D that talk about the public staff's responsibilities and duties to undertake certain actions that, and I don't know that there's any disagreement about this, but any actions that aren't particularly relevant to what we're about today. But subsection 12, which states that when deemed necessary by the executive director in the interest of the using consuming public, advise the commission with respect to securities, regulations, and transactions pursuant to the provisions of Article 8 of this chapter. And it's your understanding that that is the provision that the public staff is leaning on to say that they have an opportunity or an obligation or right to participate in the structuring, marketing, and pricing for the bonds. Is that right?
Yes.
Okay. Can you, the only way I can make that make sense, and maybe you can illuminate on this is, I mean, clearly there's nothing in subsection 12 that says, and the public staff can participate as a co-equal decision maker in issuances by public utilities. You'd agree with me that it does not say that, right?
Yes.
Okay, and there's no other, well, let me ask you this. Are you aware of any other statute, and I'll make the exception for the one we've already identified, 62-172, 12, which is where you base the argument that basically the cleanup clause, the ability of the commission to make additional orders that aren't inconsistent with 62-172. Other than that provision, which is what the public staff is hanging its hat on, in addition to 62-15 D12, are you aware of any other provision of North Carolina law or commission regulations that would support the public staff as a consumer advocate participating in a securities issuance by a public utility, or in this case, a special purpose entity owned by the public utility?
I'm not.
Okay. I think that's all the questions I have from Ms. Klein. Chair Mitchell.
All right, Mr. Grantmeyer, redirect.
Yes, I have several questions. Ms. Klein, do you still have GS 6215 in front of you?
Yes, I do.
Now, I refer you to section D. Do you see section D on the first page of that statute?
Yes.
And you see it says D begins, it shall be the duty and responsibility of the public staff too. You see that, don't you?
I do see it.
Now, in Texas, you didn't have a public staff in the commission, did you?
No, we did not.
And really, in the cases before the Texas Commission, the commission staff would file testimony on behalf of customers or in the customer's interest on occasion. Is that correct?
That's correct.
Now, on this statute, it also says under D3, could you please read what D3 says? where it says it shall be the duty and responsibility of the public staff to, number 3, could you read that? Intervene on behalf?
Yes, it says intervene on behalf of the using and consuming public in all commission proceedings affecting the rates or service of any.
Now, these storm security charges are really part of the rates. They may not be part of the base rates, but the customers are paying this as part of their utility bill. Isn't that correct?
That's correct.
And so to the average customer, this is rates. Would you agree? To the uninformed customer like Bill Grantmeyer, it may be rates?
I would agree.
Now, do you feel that this language is very strong? It doesn't say that public staff may intervene. It says the public staff shall intervene. Do you consider that strong language?
Yes, I believe that it's a very unequivocal directive.
Now, in your Texas proceeding, you said the bond team, including the commission's financial advisor, was able to communicate with third parties. Is that correct?
Yes, they were at the table communicating with and negotiating with third parties in every aspect and every meeting because the commission acted through its financial advisor. So
Chair Mitchell, excuse me, Ms. Klein, I would object to this question. I did not ask any questions concerning the role of the Texas Public Utility Commission staff. And as far as I know, redirect is intended to be limited to the scope of cross.
I would say that they brought up the question about the activities with the third parties, or she did in her answer, and we have the right to follow up on that.
All right, I'm going to overrule the objection, Mr. Grantmeyer, stick to redirect.
Did they have any, so they did have interaction with third parties. Who would be the third parties that they interacted with?
That would be investors, and I'm sure there were others in addition to investors that they had to negotiate with and communicate with. Basically, any third party that the utility would find themselves interacting with as well in this process.
And when you were the chair of the Texas Commission and a commissioner, these 3 ratepayer-backed bond issues, was this a new process for the Texas Commission?
When I was chair, it wasn't. There were some previous securitizations that were already completed in which the financial advisor was also used.
Now, you were asking on the bond team, could you please give a brief summary of why you feel the ratepayers need a participant in the bond team in addition to the commission, the appointed commissioner, or the commission staff?
Objection, Chair Mitchell. Again, I ask about the commission's participation and whether the commission's participation satisfied or results.
He asked about the composition of the bond team, and we have the right to follow up on that as to what her position is as to the composition of the bond team and why.
All right, one more time, I'll overrule the objection, but Mr. Grantmeyer, stick to redirect, tailor your questions to questions that the witness was asked on cross-examination.
This is my last question. If I can remember it, I'll ask it again. Would you please summarize why you believe it is necessary to have the ratepayers have a member of the bond team with decision-making authority?
Yes, because given their mandate to be a part of the proceedings of the commission representing ratepayers, that that voice table during these processes, especially to incorporate that voice equal with, those entities that are on the other side that are not representing the ratepayer, like the underwriters, for example, or that have other conflicting interests like the utility.
Thank you. I have no further questions.
All right, we will entertain questions from commissioners, starting with Commissioner Brown Bland.
No questions.
Okay, Commissioner Gray.
I have no questions for this witness.
Commissioner Clodfelter.
Thank you. Nothing from me.
And Commissioner Duffley.
No questions.
All right, Commissioner Hughes.
No questions.
Commissioner McKissick.
Questions.
All right, Ms. Klein, I do have several questions for you. Can you help us understand, one, who is or what is the Texas Office of Public Utility Counsel, and what role did that organization play, if any, in the securitization proceedings?
Yes, they are an office that has a separate agency, not under the jurisdiction of the commission. And they do represent residential and small commercial customers, and they are interveners.
Okay, and so did that organization play a role in the proceedings or intervene in the securitization proceedings?
Yes, they were interveners in the proceedings.
Okay, and were they a member of the bond team in any capacity?
No, they were not.
Okay.
And they were not because we already had ratepayer interests represented in the commission.
Okay, and just explain for me what you mean when you say that. Help me understand specifically what you're saying there. When you that you already had ratepayer interest represented in the commission.
Because the commission is the utility commission in Texas, is authorized to represent payers and not just regulate utilities, but also represent payers as well.
So do you understand
what interest goes?
Okay, I apologize for interrupting you. You may need to restate your response for the court reporter's purposes.
So, they don't just regulate utilities, they also represent the public interest, which is ratepayers are part of that public interest.
Okay, so do you understand the statutory authority of the Public Utility Commission of Texas to be different from that of the North Carolina Utilities Commission?
That's correct.
Okay. All right, I have nothing further for you, Ms. Klein. Thank you. Questions on commissioners' questions from the company?
No further questions, Chair Mitchell.
Okay, Mr. Grantmeyer?
Public staff has none, Chair Mitchell.
Okay. All right, Ms. Klein. Well, thank you very much for your time today. We have come to the end of your testimony. You may step down, and counsel will entertain motions.
I move that her testimony be admitted into evidence and exhibits 1 through 4 to her testimony be admitted into evidence.
All right, hearing no objection, the motion is allowed. All right, Ms. Klein, thank you very much.
Thank you.
Thank you.
All right, Mr. Robinson, we are back with you.
Thank you, Chair Mitchell. We have Mr. Charles Atkins, who's up next, and that'll be Jim. Thank you.
Okay. All right, let's see, Mr. Atkins. There you are. All right, would you raise your right hand, please, sir? Do you affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do, yes.
All right, thank you. Mr. Jeffries, you may proceed.
Thank you, Chair Mitchell. I'm going to have to talk to Mr. Robinson about the allocation of effort here today after the hearing's over, but I know everybody's probably getting tired of hearing me talk, so we'll try and get through this as quick as we can. Mr. Atkins, could you please state your name and business address for the record, please?
Yes, I am Charles N. Atkins II, and my particular business address is 170 East End Avenue in New York. And New York, zip is 10128.
Where do you work, Mr. Atkins?
I work at Atkins Capital Strategies, and I serve as the Chief Executive Officer.
Okay. Are you the same Charles Atkins that pre-filed direct testimony in this proceeding on October 26, 2020, consisting of 60 pages and Atkins exhibits 1 through 4?
I am, yes.
Was that testimony and were those exhibits prepared by you or under your direction?
Yes, sir. Yes, sir.
Do you have any corrections to that testimony or those exhibits?
I don't. No.
Mr. Atkins, if I asked you the same questions as are set forth in pre-filed direct testimony while you're on the stand today, would your answers be the same?
Yes, sir.
And are you also the same Charles Atkins that pre-filed rebuttal testimony in this docket on January 11th, 2021, consisting of 17 pages and Atkins rebuttal exhibit 1?
Yes, sir.
And was that testimony and that exhibit prepared by you or under your direction?
Yes, sir.
And do you have any corrections to that testimony or exhibits?
I don't.
And if I ask you questions that are set forth in your pre-filed rebuttal while you're on the stand today, would your answers be the same?
Yes, sir.
All right. Chair Mitchell, move that Mr. Atkins' pre-filed direct and rebuttal testimony be entered into the record as if given orally from the stand.
All right, hearing no objection to your motion, the pre-filed direct and rebuttal testimonies of Mr. Atkins shall be copied into the record as if delivered orally from the stand.
And we would also request that Mr. Atkins' exhibits, direct and rebuttal exhibits, be identified as pre-marked.
All right, and the exhibits to Mr. Atkins' pre-filed testimony will be identified as they were when pre-filed.
Thank you, Chair Mitchell. Mr. Atkins, have you prepared a summary of your pre-filed direct and rebuttal testimonies?
I have, yes.
And could you please provide that for the commission?
Of course. Good afternoon, commissioners. My name is Charles Atkins, and I am CEO of Atkins Capital Strategies, LLC. I am serving as a co-financial advisor to Duke Energy Carolinas and Duke Energy Progress, which I refer to collectively as the companies and separately as DEC and DEP. I am pleased to appear before you in connection with the company's joint petition for storm cost recovery financing orders. By way of background, while these storm recovery securitization transactions will be the first such transactions done in the state of North Carolina, these transactions are not new to the marketplace. There have been 66 of these transactions sponsored by or related to investor-owned utilities since 1997, and which total over 50 billion in bonds issued. Not only are Duke Energy and its family of companies experienced and also are sophisticated issuers of debt, issuing many billions over the years, these transactions will not be the first securitization for Duke Energy. The 2016 $1.29 billion transaction sponsored by Duke Energy Florida is the largest recent utilities securitization, the longest large transaction with a 20-year scheduled final maturity, and the first utilities securitization to be included in the Bloomberg Barclays Corporate Index. The securitization process can result in a AAA rated debt that is insulated from the bankruptcy risk of the sponsoring companies, so that the company's customers may also benefit from a cost of capital that is based on 99.5% of AAA rated debt, instead of the much higher regulatory weighted cost of equity and debt capital that is used in the traditional cost recovery. This lower cost of capital can result in important savings for customers, estimated at approximately 30%, as described by company's witness Heath. There are three main strategies that the companies may use in issuing these bonds to investors. One factor to consider in assessing each of these alternatives is the potential for inclusion in the Bloomberg Barclays Corporate Index. A lot of investors perceive bond issues that are included in the index to be more tradable or more liquid, and therefore more attractive than bonds that are not index eligible. However, there is an absolute, a minimum $300 million issue size requirement for potential inclusion in the corporate index. Therefore, a standalone DEP transaction would satisfy that the size requirement, but a standalone DEC transaction under these circumstances would not. One potential issuance strategy is to market and price the DEP and DEC storm recovery bonds separately, spaced out by several weeks or months. This particular separate issuance strategy would mean that the two transactions would face different interest rate and market conditions, and may have different interest rates that would drive the amount of customer charges these two customer bases would actually pay. In addition, carrying costs on the second transaction would increase due to the delayed issuance. A second issuance strategy would involve marketing and pricing the DEC and DEP transactions simultaneously. Unlike the separate issuance approach, these two transactions would face the same market conditions. However, given that index eligible bonds are generally believed to be more attractive than bonds that are not index eligible, there is no way to ensure in advance that the smaller DEC transaction would not be disadvantaged when compared to the larger index eligible DEP transaction. The third issuance strategy is the SRB security structure discussed in my direct testimony, which would be structured to be eligible for the corporate index. This structure involves SBE subsidiaries of DEC and DEP issuing storm recovery bonds to a bankruptcy remote trust wholly owned by Duke Energy. This trust would then issue notes to the marketplace backed by the DEC and DEP bonds. The interest rates on the trust note tranches would set the interest rate for each of the tranches of the DEC and DEP bonds. Thus, each corresponding tranche of the DEC and DEP bonds would have the same interest rate. While there are certain incremental costs associated with the SRB security structure, which would be reviewed closely, this structure would result in securitization charges based upon the same interest rates, thus eliminating the risk that the smaller DEC transaction might be treated less favorably. The companies are fully committed to satisfying their statutory cost objective obligations, including the lowest storm recovery charges consistent with market conditions at the time the bonds are priced. The companies will evaluate closely all of the potential benefits and considerations involved in each of these strategies. Specifically, the companies seek approval of proposed financing orders containing all of the key elements for AAA ratings, as well as the flexibility to assess different structures or various structures and issuance approaches based upon rating agency and lead underwriter and investor feedback, as well as other real-time market factors. If the commission chooses, the companies have indicated support for a bond team approach, which is also similar to the Duke Energy Florida transaction, where there would be a working group that would participate in the development of the transaction structures and would also review marketing plans and the transaction pricing. The bond team will consist of the companies, their advisor, and counsel, the commission and its independent outside consultants and or counsel. The role of the commission here is unique since it is the commission which makes specific findings that are the key to the creation of the storm recovery property. And it is the commission that issues the financing orders. The bond team would receive ongoing feedback and advice from the lead underwriters, the public staff and its consultants, and their respective counsel. This concludes my testimony. I look forward to our discussion.
Thank you, Mr. Atkins. Chair Mitchell, Mr. Atkins is available for cross-examination and questions by the commission.
All right.
Mr. Atkins, my name is Bill Grantmeyer, Public Staff Attorney. Were you listening to the questions on Mr. Heath earlier?
I was, yes, sir.
And you may not know the answer to this, and if it's beyond your field of expertise, that's okay. I don't know how much you know about utility rate making, but he answered twice, once that the payment of normal utility bonds, I'm not talking about ratepayer backed bonds, just the regular mortgage, first mortgage bonds or whatever, are ultimately the responsibility of ratepayers. And then he said all utility debt is paid by customers. Now, my question is, isn't it true that if a utility goes out and issues a first mortgage bond outside of a rate case, that the payments on that bond do not go into rates until the next rate case when it's incorporated into the embedded cost of debt? Are you familiar with that? If you're not, it's okay to say, because I know you're not a rate case guy.
I am not a rate case guy.
Okay, very good. Okay, now going to your testimony on page 4, line 3. This is your direct. What we're going to do is go through your direct testimony, and then we'll finish up with your rebuttal, if that's okay. In that, you say that you testified or you were involved in 25 securitizations that included SEC approval. Is that correct?
Those were all SEC registered transactions.
Now, did any of those?
As I recall, I guess.
Now, Mr. Heath was worried about civil actions by the SEC as a result of the transaction. In any of those 25 transactions, was there a civil action filed or a criminal action filed by the SEC?
I would say no, but in each of those transactions, every single party has to be extremely careful.
And in some of those transactions, there was a bond team. You were involved in the Florida transaction with the bond team where Sabre Partners was involved, and there was no SEC civil action or criminal action, was there?
I was not involved in that particular transaction.
Okay, thank you. Now, on page 11, line 2, I'm getting there. I'm sorry. Page 11, you look on line 2, you have the words, particularly since this will be the first securitization financing orders in North Carolina. So you would admit then that this commission is new to securitization financing, and would you agree, anytime you're doing something you've never done before, it's good to get as much guidance as you can?
I would say that the scope of the company's proposal, it is actually based upon a lot of experience. And so I think that the proposed transaction documents are an excellent foundation for a transaction here.
But you say the company is experienced in normal debt, and they've done this securitization in Florida, but the company represents the shareholders and not the customers. Isn't that correct?
I would disagree in that I think that interests are aligned in that because this debt is also treated as on-credit debt, especially at Moody's, that there is a strong incentive for each of these companies to work extremely hard to achieve the lowest costs. Interests are aligned there.
Well, there was testimony earlier, and do you agree that S&P does not consider this as balance sheet debt? Is that correct?
It is correct, but there is also Moody's as well.
And also for rate-making purposes, it would not be considered debt on the company's capital ratio of debt to equity, and therefore it would not lower the company's equity percentage or require additional equity to balance it out. Isn't that correct?
What it does do is that the company gives up equity return on these assets, and so that does have an impact on its overall credit ratios, especially at the Moody's.
Now, I turn you to, yeah, I'm sorry, go ahead. Did you have?
A negative impact.
Okay. Now, I turn you to page 14 of your direct testimony. And line 4, where it says these transactions are well understood by many investors. Do you see that?
I do, yes.
Now, I turn you to your Atkins Exhibit 3, which is a part of your direct testimony. This lists the 66, as you listed, utility securitization transactions. You see that?
I do have it, yes.
Now, would you agree in the far right column, it says pricing date. Would you agree that since 2014, there's only been 4 of these transactions?
Agreed, yes.
And that's a period of 6.5 years. So right now, they're not very frequent as compared to the past, is it?
I would say that these are not done every year, no.
And compared to the past, if we could go back, say, to the second page in 2001, would you accept that there were 8 transactions in that same year? I counted them. You might trust me. I don't count very well, but it is 8.
It looks like 8, yeah.
And the next year, 2002, there were 4 in that year. Would you agree to that?
I would guess so, yes. I'll take your word for it.
So can we basically agree that they're a lot less frequent in the last, since 2014 than they were in the early 2000s of 2001, 2002?
I would agree, yes.
So if in fact they're less frequent, the investors would be less informed as to the unique characteristics of this type financing. Isn't that true?
I would say that any particular marketing process is going to be quite a robust process, and that there will always be investor education, even when there is a frequent asset class, there is always going to be investor education.
Well, if we could turn to page...
I'm sorry, I didn't understand the last part of your answer.
I just said that there will always be a lot of investor education as an ongoing part of a marketing process.
And did you use the word robust marketing and education, or did I imagine that?
I did, yes.
Okay. Now on page 33, line 17, you're talking about towards the end of the line, an effective marketing strategy should enable investors to evaluate the transaction. Do you see that?
I do, yeah.
Now, would you agree that the more, as you said earlier, the more robust and the more skilled the marketing strategy and educational process is, the better response is probable from the investor class? Would you agree to that?
I would, yes.
And would you agree that Sabre Partners is experienced in marketing and making presentations to investor groups, and also active in dealing with the Securities and Exchange Commission?
I do not have any information about their experience with the SEC. I do know that they have been quite active in their role of advising commissions. They are not a broker-dealer, and so they are not involved in the actual market making or the actual trading of bonds. And so I don't think that they have the same amount of market knowledge that underwriters do, who are actively involved in the actual marketing and in the actual trading of the bonds.
When you talk about underwriters, isn't it true that the underwriters have no fiduciary duty whatsoever to Duke in this transaction?
That is a technical legal point, but I will say that underwriters tend to be competitive. Underwriters tend to they have a lot of professional pride, and they are always seeking to do additional business. And so where you have 2 or 3 lead underwriters, I think that there will be a lot of valuable feedback. And so I think that there will be a lot of positive competitive tension there. And so I think that underwriters can and will do an excellent job, especially when you have an experienced company issuer here.
Now, are you aware of the data response made by the company that neither the underwriter nor your firm has any fiduciary duty to the Duke companies? Is that correct?
I am aware of that, yes.
Now, and again, neither the underwriters nor you would have any fiduciary duty to the customers, then Duke's customers, would you?
That is a technical legal point, yes.
Now, with regard to the underwriters, did you hear the testimony? I thought I heard that the fee going to be paid to the underwriters, I believe, was something like $3.8 or $3.9 million. Is that what you remember hearing?
I did hear that, and underwriters, as they do undergo an ongoing marketing process, and they do take the absolute full risk that investor orders will absolutely fail. And so they are taking underwriting risk on every transaction.
Well, wouldn't the higher the interest rate on the bonds, the higher the interest rate is, the less chance the transaction is going to fail, isn't it?
I would say that in each case, and especially here, that there will be a transparent marketing process where the order book, where the actual investor orders will be right there, and the joint decision makers will be able to see which investors have made which orders, and then there will be a particular transparent process of issuing spreads until there is a fully subscribed deal at the absolute the lowest price, which is attainable.
But you would agree that the more robust the marketing is and the more skilled it is, the more orders you should get for the bonds, assuming that the investors understand the almost non-existent risk here. These bonds, the risk is virtually non-existent. Would you agree to that?
There is a particular credit spread associated with these bonds. And so I believe that it would be inaccurate to say that there's almost no risk here. I would say that there is a AAA risk, but there's risk. And the absolute fact that these bonds have what is called a credit spread, which means that these bonds are issued at an interest rate which is higher than a particular U.S. Treasury rate. That absolutely means that there is a different risk associated with these bonds. And it is also true that unlike other structured debt, these bonds don't have over-collateralization, which means that there are not extra assets which are being pledged here, that there is no real excess coverage. And so that just means that all of these bondholders really are looking to the ongoing true-up process in order to ensure that these bonds are going to be paid. And so there has to be complete confidence and absolute faith that the investors have that there's going to be a very, very smooth true-up process in order for these bonds to be paid, because there isn't any extra cushion here like there is for a credit card deal or a student loan deal.
But the true-up basically almost fully protects the investors in that the commission will change the charge to the customers to make sure there is enough payments. And would you agree that also that Duke is an experienced company dealing with true-ups, as is the Utilities Commission?
I would say that Duke is experienced, and I would say here that these particular true-ups are being implemented by the servicer, which is a Duke entity, and there will be an advice letter that is given to the commission, which it should be an automatic process. It is a formula-based process where the commission by the statute, the scope of the review of those true-up letters is only for mathematical or for clerical errors. Otherwise, it needs to be automatic. And so it is quite important that the investors and also rating agencies have the understanding and the faith that the true-up process is going to be an automatic, formula-based process where there will not be any interveners there, that it is an automatic process.
Well, I turn your attention to page 42 of your testimony and on line 17, and I'll just read it. It says the underwriters will work with and make recommendations to the companies throughout the process. But as we've said earlier, the underwriters really have no fiduciary duty to the company. And isn't it also true that underwriters are also driven to complete the deal as quickly as possible so they can move on to the next deal, which may be 3.8 million or maybe more or less? Isn't that a fundamental incentive for underwriters?
Underwriters have an incentive to do an excellent job, and they always want to do their best job, and they especially are going to want to do a good job for Duke. I would, and also in order to be hired by Duke again. And so I think that incentives are all aligned here. I think that Duke has an incentive to keep all of these charges as low as possible because especially Moody's has highlighted that having these particular super priority obligations reduce the amount of flexibility that these companies have in order to do capital investments and in order to invest in clean energy and other things. And so, and then there could also be additional storms. And so I think that all of the incentives are aligned in order to keep all of these charges as low as possible.
Now, I turn you to page 43 of your testimony.
All right, Mr. Grantmeyer, I'm going to interrupt you here for just a moment. We are going to take a very short break for our court reporter. Let's go off the record. We'll go back on at 4:05.
You're all very prompt. I'm ready.
Okay, perfect. Thank you. You anticipated my question.
So we're ready to go then?
Not quite yet. Let me give my colleagues, they have 30 more seconds to get on the line here. All right, before we go back on the record, just want to announce we will resume tomorrow morning at 9 o'clock in the morning, and we will go until 5 o'clock with breaks along the way for lunch and our court reporter. All right, with that, let's go back on the record. Mr. Grantmeyer, you may resume your cross-examination of the witness.
Mr. Atkins, earlier we were talking about the U.S. Treasury bond rates. Isn't it true that they are exempt from state taxes, and therefore that's one reason their rates are lower?
I would say yes, but I think that they are deemed to be, well, they are considered to be risk-free, even though it is a sovereign credit and it still has risk. But at least in these markets, it is considered to be risk-free, but it does have risk.
And going back to where we were on page 43, I'll read the two lines. It says, extensive education will be provided to investors regarding storm recovery bonds, and in particularly investors who may be new to this asset class. So this follows up for what we talked about earlier, that there are new investors to this asset class. There have not been as many transactions recently. And basically, would you agree that there needs to be very strong education, as you say, extensive education? Would you agree to that?
I would agree that the underwriters and the company through the Investor Roadshow can educate investors about the specific strengths of this transaction. And so there is a particular formal process that has to be taken, especially since these are SEC transactions. And so that has to be done quite carefully. It can be done in a particularly robust way, but it has to be done carefully within the SEC regulations.
But the key word, you said that they can do this education. We have no assurance that they will do extensive, robust education, do we?
There is going to, well, if you take a look at the proposed issuance advice letter, as a part of that particular issuance advice letter is a company certification. And as a part of that particular company certification, there is a specific checklist that includes a host of marketing activities. And so investor education will, of course, be a part of that overall marketing process. And so in the Duke, the Florida transaction, over 100 investors were contacted, and there were more than 50 investors ultimately in that transaction. And so I think that Duke has experience in terms of overseeing a quite robust marketing process.
But it's true that Sabre Partners was also involved in that process, also involved talking with investors and participating in the marketing. And so when you say there was 100 investors, how many of those could you attribute to the Sabre Partners contribution?
I cannot really attest to that. I was not a part of that transaction, but I was informed about the overall number of investors who were contacted.
Now, do you have in front of you a copy of the Duke Energy proposed financing order that they filed with the joint petition?
It is in a thick book. It is being found now.
Okay, and I'm going to refer you to what they call Appendix C, which is the form of the issuance advice letter. It's on page 78 of 94 of the joint petition.
I do see it, yes.
You got it?
Yes, sir.
And I don't know if you read this recently, but would you agree that nowhere does it say in here that there was any, it really describes the marketing that the company did, or it's not going to report anything about the marketing?
Hold on.
Mr. Grantmeyer, let us know where you are, where you're looking right
now. This is the issue advice letter, and it goes down on page 1. It starts with name of what it's going to report, and then on the top of page 2 again, and then it lists all the representations. But I just don't see anywhere in the document it talks to describe the marketing efforts.
If you look what is called Attachment 8, which is the form of the company certification, which is a part of the issuance advice letter.
Would you be kind enough to tell us what page you're talking about? Or Attachment 8?
Yes, Attachment 8. I don't see a page number here. But it is the form of company certification.
And where on this form does it describe in detail the marketing efforts?
There is a whole list of actions that there is a set of particular bullet points where it talks about on the next page. It says that it developed all bond transaction documents, the marketing materials and so forth, and then also goes on to say allowed sufficient time for investors to review marketing materials and ask questions, and attended investor meetings. And also goes down to say, it talks about marketing plan, and it also involves conversation with the underwriting team And it talks about conducted in-person and telephonic road shows over X number of investors in X number of cities. And so it talks about a lot of actions here. And so this is an overall form, but it does provide a checklist of actions which are going to be taken in order to achieve the statutory cost objectives. And so it does include investor education and the marketing here. And this is part of the company certification.
Okay, I will turn you to page 44 of your testimony. On line, excuse me, I'm flipping pages here. Now, nowhere does it say on that certification they made the master record known as the book. They don't go into a description on that, do they? Isn't that the indication of about who is contacted, where they keep track of all the contacts with investors? But that is not in the certification, is it?
I don't think that particular aspect is, but there is an overall overview of the overall marketing process and the investor roadshow. It does specify how many investors will participate in the overall investor roadshow.
Now on page 46, line 8, you talk about if the tranche is oversubscribed, they may continue to lower the pricing level. Is that correct?
Yes, sir.
So the more robust and skilled the marketing is, the better chance you have, would you agree, the better chance you have to be oversubscribed and therefore keep lowering or lower the pricing on the bonds or the interest rate on the bond?
I would say that there is a real art to the overall issuance strategy, and that you should have an experienced team of underwriters who will actually build upon the overall pre-marketing process in order to come up with what are the particular levels which will be given through the price guidance process. And so I think that is a particular process that will be closely coordinated with the elite underwriters who are market makers and who have a secondary market trading desk. And so they are in the intimate touch with the current market conditions and in consultation with the experienced issuer and also with the commission representative to undertake an issuance strategy and to come out with initial price guidance after the overall marketing process. But this is a process that has to be done quite carefully.
Mr. Grantmeyer, you're muted.
That might not be a bad idea sometimes, but anyway, we're going to your rebuttal testimony. I'm sorry, and which means we're getting closer to the end here. And on page 4, line 18, you talk about in none of your previous securitization transactions with investor-owned utility where an intervener was a member of the bond financing or bond team. Is that correct?
Yes, sir.
Now, earlier, were you here when we had Public Staff Heath cross-examination exhibit number 1, which is the statute, general statute 62-15, talking about the public staff? Do you have access to that?
I do.
And do you have it available in front of you?
I do.
And would you agree that under D, it says it shall be the duty and responsibility of the public staff to, and then down on 3, intervene on behalf of the using and consuming public in all commission proceedings affecting the rates or service of a public utility?
I do see that, and I also see in section B there that the public staff shall not be subject to the supervision, direction, or control of the commission.
But in B, doesn't it also say at the beginning there is established in the commission? I use the word in the commission, a public staff. Isn't that what it says?
It does say that, but it also makes it quite clear, and I believe that the public staff's website does also cite that the public staff is independent. It even says that it is an independent agency. And so
we're
I think that this particular statute,
we're proud to be independent, but we're also proud to be established in the commission. Also, but how many of the other cases where you say you never saw an intervener, were they required by statute to intervene?
You know what? I believe that the public staff has intervened in this case.
I know that, but I'm talking about, it says it shall. We have a legislative General Assembly order that we shall intervene. How many other cases is there that language that you've been involved in that the intervener was required by statute to intervene?
I am not aware of any other case, but I believe that the public staff has intervened and is also giving a lot of input into this overall process during this particular phase.
Now, Chair Mitchell, I would request that the commission take judicial notice of Commission Rule R1-19 called intervention. I'm not going to make it an exhibit, but I just want to ask him a question about it. And it'd be a general question to paraphrase it. And it is on the list of our redirect exhibits, but it's kind of a general question.
Chair Mitchell, yes. To the extent that we're going to ask Mr. Atkins questions about the commission rules, I don't have any objection to that. I just would like him to have a copy of it in front of him. And I'd also like to take a second to get a copy in front of me.
All right. Well, what I heard Mr. Grantmeyer say is that it is included in the document.
It's the public staff redirect exhibits, and it's the very last one. Whatever that number is. I don't have electronic access.
We should have it.
It's 72. Redirect 72.
All right. I have a copy, Chair Mitchell, and hopefully, Mr. Atkins, do you have a copy of it yet? Excellent. All right. Thank you.
And would you agree, Mr. Atkins, that...
Hang on, Mr. Grantmeyer. Let me, for the purposes of the record, the commission will take judicial notice of Commission Rule R119. All right.
Okay, since we have it in front of us, I would request that this be identified as Public Staff Atkins Rebuttal Cross-Examination Exhibit 1.
All right, Mr. Grantmeyer, we will identify the document as Public Staff Atkins Cross-Examination Exhibit 1.
Now, I know you haven't read this in detail, but I'm just going to summarize it. It says at the top, contents of petition. So, and then halfway down, in order to become an intervener, you must file a petition. That's about 8 lines down. Do you see that?
I do. Yes, I think I do. Yeah.
And so you would agree that interveners in North Carolina, at least pursuant to this rule, other than the public staff and maybe the attorney in the Attorney General's office, must file a petition to become an intervener. A verified petition.
You know what? I really haven't read this, and so.
Okay.
I think it says what it says.
Okay. We can agree it says what it says, but the commission must approve. We do agree that if you have to file a petition, the commission must approve you as an intervener.
I think it says what it says.
Okay, it says what it says. We'll move on. On page 5, line 14, you have the words, it says, however, to the extent the commission wishes to undertake a significant level of post-financing order involvement, the companies do not object to that, similar to Florida. Is that correct?
Yes, that's correct.
But in Florida, the commission hired Sabre as its advisor. Isn't that correct?
That is my understanding.
And you're aware that the commission does not have its own outside financial advisor at this time. Is that correct?
That is my understanding.
And if in fact the commission is going to issue a financing order by February 8th or within the 30 days thereafter, that is would you agree that's a very limited time for them to go out, search for, hire a financing advisor or financial advisor and get any meaningful input?
I believe, and I have also participated in a quite vigorous, quite vigorous regulatory process that is leading up to that is a part of the consideration of these 2 financing orders. And I do believe that there has been a great deal of input by the public staff, and that the public staff has been quite ably represented. And so I think that there has been a quite robust ongoing process that we are engaged in right now that gives the commission a lot of food for thought. And so I think that the public staff has been quite active.
But you would agree this commission has never dealt, or to your knowledge, with a securitization bond issuance similar to this, where the commission has to get down into the weeds as to the marketing strategy, the documents, and actual pricing. Would you agree with that? If you've never done it before, how are you supposed to know about it? How did all the items that all the knowledge that you're supposed to have?
I would say that that the commission still has time to appoint a financial advisor that is an experienced financial advisor that could advise it if it chooses to have a bond team. And so there will be a process that will take several months. And so it would not take a lot of time in order to choose its own advisor.
Yeah, but isn't the key piece that they have to issue the financing order? And doesn't the commission need a lot of advice from either the public staff's financial advisor or its own as to the key pieces they should put in the financing order?
You know what? I think that there is an ongoing process that is taking place now where there is quite a large amount of input that is coming from the public staff and the public staff consultants. And so there has been a lot of opportunity to provide input about the terms of the financing order. And I even think that even after this hearing, there will be additional opportunities for input. I believe that the public staff, that Mr. Creech actually mentioned that. And so I think that the public staff clearly has intervened, and it clearly is giving input.
Now, are you at all familiar with the Florida Commission and the functions of the staff as far as the Florida staff filing testimony representing customers? Are you familiar with that at all?
I have not participated in any transactions in the great state of Florida, unfortunately.
And will you accept, subject to check, that Florida does not have a public staff similar to the North Carolina public staff that's connected to the commission?
Objection, Chair Mitchell. Mr. Atkins has already indicated he doesn't have any knowledge of the state, what happens in the state of Florida.
Grant Meyer.
Well, if he wants to say he doesn't know, that's fine.
All right, I'll overrule the objection. I'll allow the witness to answer.
No.
Now, with respect, this last question, so that's the good news. Oh, one other question. When you said that the public staff was ably represented. I'm assuming you're talking about Sabre Partners and not the two public staff lawyers. Is that correct?
I believe that the law, that a legal education is fantastic. I also am a lawyer, and so I was speaking about the public staff lawyers.
Okay, last question, I promise. Now, one of the things the bond team would do, isn't it correct, whether Sabre is part of the bond team and the public staff, they would be able to make the decision if you had a single SPE or you had two separate SPEs issuing the bonds for Duke Energy Carolinas and Duke Energy Progress. Isn't that true?
I would say no, that under the company's proposal, the bond team is not a decision maker, that only two people, the person who is the representative of the company and the other person who is the representative of the commission.
But those two, I'm sorry, go ahead.
Excuse me. Those two people are advised by other members of the bond team, i.e. the advisor to the company and the counsel to the company and the advisor to the commission, if one's hired, and the counsel to the commission. Underwriters would be invited to participate and advise the bond team, and also the public staff and the counsel to the public staff and the able consultant to the public staff would also have an opportunity to advise the bond team. And so, but the decision making would be those two identified people that are identified.
I'm sorry, one follow-up question. You realize the public staff's proposal is that there be the bond team with the public staff having equal decision-making authority with the company, and that if they, and also the selected commissioner, if it's a commissioner in the bond team, would also have decision-making authority. But if there was ever a dispute between the company and the public staff, that the presiding commissioner would have the ultimate decision-making authority. Is that, do you understand that?
I did hear that, yes.
Thank you. I have no further questions.
All right, Mr. Jeffries, redirect of your witness.
Thank you, Chair Mitchell. Mr. Atkins, early in your cross-examination, Mr. Grantmeyer asked you some questions about the 25 prior bond transactions you've worked on, and specifically whether there were any lawsuits filed after those transactions. You recall that testimony? I'm sorry, I think you're on mute, Mr. Atkins.
I do, yes.
Okay. Did any of those 25 prior bond transactions involve an intervener with co-equal decision-making authority, to your knowledge?
Absolutely not.
Okay. And not to beat a dead horse, but I want to make sure the record's clear on this. Mr. Heath talked about it a little bit. You talked a little bit earlier. Could you I'm having a little trouble completely understanding the nuance between how securitization is treated on the balance sheets, or will be treated on the balance sheets of the utilities and the holding company, and sort of the positions of S&Ps and the positions of Moody's on that. Could you explain that for me?
Sure. I will start out by basically saying that from a particular GAAP account point of view, all of this debt is consolidated in the financial statements of Duke. From time to time, there may be a notation in those financial statements that this is non-recourse debt, but it is still consolidated for GAAP accounting. S&P takes an approach where if these are all properly structured, that they will adjust the credit ratios, and they will take these bonds out of the company's credit ratios. And so it is treated as off-credit debt under S&P's rating approach. As far as Moody's goes, they take a completely different approach. They will treat it as on-credit debt. And so in their particular report, there is a particular report that was done in July of 2018, which is called, which outlines how they particularly treat it. And they do note that in early years of the securitization transaction, that it does have a negative effect on the company's cash flow from operations versus working capital and debt credit ratios. It also goes on to say that the particular presence of securitization debt, it reduces the amount of headroom that the company has to do other things in its rate base and to increase rates for other purposes. And it does also go on to also say that it can reduce the particular flexibility of a company to include capital investments in its rate base. And so, especially in the case of storm recovery, with the climate change, which has been highlighted by the public staff consultants, there is a quite possibility of additional storms and the need for additional storm recovery bonds. And I believe that the companies are well aware of that. And so, given the fact that these bonds are on credit at Moody's, and given the fact that the companies treat the they do view their particular Moody's ratios as being important, and they are not unimportant. And given all of that, incentives, there are strong incentives for the company to keep the customer charges as low as possible, because that would tend to minimize any type of negative impact as far as headroom goes. And it also would tend to give space for additional transactions if there are additional storms. And it's good for customers to keep those charges as low as possible. And so all of the incentives are aligned.
Thank you. I feel like I understand that now. I appreciate that response. Mr. Atkins, you've participated in quite a few issuances of long-term debt in the capital markets. Is that correct?
Yes, I have a few here. Yes.
And did all of those transactions involve underwriters?
Yes.
I'm sorry, was that a yes?
Yes.
Okay. So in your experience, does the fact that an underwriter may have an economic interest in pursuing a particular transaction mean that that underwriter is incapable of working to achieve the issuer's lowest cost objectives?
Underwriters are always trying to get additional business, and underwriters are not doing these transactions off of their own. They are part of an ongoing working group, and they are always overseen by the company. And there is a transparent order book, and so the company, and in the case of a securitization, the decision makers will actually see where the orders are and aren't.
Okay, great. I have one last area I'd like to ask you a couple of questions about. And do you recall Mr. Grantmeyer asking you some questions about, I guess, how is the commission going to know that, that the companies are engaging in appropriate marketing activities and sufficient marketing activities with respect to these bonds? So let me test my understanding of how this works. So even if the transaction was just the companies and you and the underwriters, who would you expect the underwriters to be in this transaction? Not by name, by description.
Oh, I would expect that there will be at least 2 lead underwriters, and there just might be 2, and that those would be large firms that have a great deal of experience in also structuring and marketing structured debt as well as corporate debt, and that they would have active secondary market trading operations. And so I think that there is a difference between underwriters who have almost 24-hour market contact and consultants like me or other consultants who are not broker dealers and who don't have a secondary trading operation and are not actively making market in bonds. And so I would expect that through an RFP process that quite experienced underwriters, especially lead underwriters, are going to be chosen.
And would you expect that between the companies, your experience and the underwriters and with the supervision of the commission, if they choose to be involved, that these combination of folks would be able to obtain the lowest charge to customers, as Mr. Heath indicated the company would certify to the commission?
I would, yes.
Okay, thank you. That's all the redirect I have from Mr. Atkins.
All right, we'll take questions from commissioners, beginning with Commissioner Brown-Bland.
I don't have any questions at this time. Thank you.
Okay. Commissioner Gray?
No questions for Mr. Atkins at this time.
All right, Commissioner Clodfelter?
No, thank you.
Okay, Commissioner Duffley?
No questions.
Commissioner Hughes?
No questions.
Okay. And Commissioner McKissick?
No questions at this time.
All right, that leaves me. I have just a few questions for you, Mr. Atkins, and I will do my best to get through them before the end of the day, so you can call it a day. All right, let's see. I want to clear up one question in my mind and your responses to Mr. Grantmeyer. I believe you referenced a Moody's report. Is that correct? Or some publication by Moody's related to this type of bond in general?
I did, yes. And it is a part of the particular record. I believe it is an exhibit. Is it cross-examined? Hold on. It's right here, but hold on.
Well, just Mr. Atkins, just to save some time, I'll ask Mr. Jeffries to confirm whether it's in the record and where.
My understanding, Chair Mitchell, is it's one of the exhibits in the public staff's designated redirect exhibits.
It's right here. Which one is it?
Cross exhibit
41.
It is cross exhibit 22.
Oh, my mistake. Let's confirm that it's cross exhibit, not redirect.
It is both. It's both, actually. It is page.
Oh, yeah.
It is page 1307.
Chair Mitchell, there are a bunch of mics that are open at the same time, and I think that's causing a lot of feedback. May bother our court reporter.
Okay. Well, at this point, you all may mute. Unfortunately, Mr. Atkins, you may not mute, but I think we've identified where the document is at this point. All right. Mr. Atkins, I have some questions for you that relate to the settlement agreement that was filed with us yesterday. And so if you are not the appropriate person to answer those questions, you can so state, but let me know who might be. All right, let me get to my question. The public staff and the companies have come to terms on the audit of the ongoing financing costs. And as I read the settlement agreement, it's a somewhat limited audit for mathematical clerical errors, charges incurred as a result of gross negligence, recklessness, or willful misconduct. I read this to be sort of a narrow, not your typical prudence review, but something less than a prudence review. Will you confirm my understanding that of the scope of the audit that will be conducted?
I did not participate in any of those conversations, but then I will say that from a particular bankruptcy remote approach, that it is key that the ongoing financing costs be actually paid through the securitization charges, because each of these SPEs must exist on a standalone basis. And so for all of the bankruptcy remote illegal purposes, it is quite important that that is a principle which is upheld. But I would defer to company counsel to speak to the details of the settlement.
Okay, thank you, Mr. Atkins. I will pose those questions to the next company witness. One question that you may be able to answer, can you help us understand sort of just a timing question? When will the decision be made as to how to structure the transaction? Whether it's you use the grantor trust structure or some other type of structure. At what point in time is that decision made?
I would advise that that would be a decision that is made after the lead underwriters have been chosen, and then after there is additional feedback on the specific cost involved. And so I think that there should be additional conversations with each of the rating agencies to basically fine tune all of those costs. And so I think that there would be a quite careful weighing of those incremental costs, and also having a view from those lead underwriters what those particular benefits are of each of those three issuance strategies. And so I don't think that that would take a long time, but it has to be done carefully. And then as the company's witness, Heath, spoke about, I think that there would be an additional look about how you allocate those incremental costs. That it could be that that a bit more of those incremental costs will be borne by the DEC customers.
Okay, thank you for that response. Can you, another timing question for you. Can you help us understand the point in time at which the storm recovery property is transferred to the single purpose or special purpose entities?
This is a particular simultaneous process, and so the particular storm recovery property is authorized by the financing order, but it springs into being at the time of the bond closing, and so it is a simultaneous process, and so that is how it happens, and so it does not get involved with any other property liens, and so that's why it springs into being just as it is being transferred.
Okay. Okay. All right. That is it from me. I'll see if council have any questions on my questions for the witness. Mr. Jeffries.
None from the company.
Public staff has none.
Okay. All right. Well, with that, Mr. Atkins, we appreciate your time, and you may step down. Council will entertain motions.
Thank you, Chair Mitchell. The companies would move Mr. Atkins direct exhibits 1 through 4 and Atkins rebuttal exhibit 1 into evidence.
All right, hearing no objection, Mr. Jeffrey, to your motion, it is allowed. Mr. Grantmeyer?
Public staff would move public staff Atkins cross-examination exhibit 1 into evidence.
All right.
No objection.
Motion is allowed, Mr. Grantmeyer. All right, with that, we have come to the end of our day. We will be in recess. We'll go back on the record in the morning at 9 o'clock. Line opens up at 8:30, so you won't be signing well in advance of our 9 o'clock.
Let's give it, Madam Chair.
Yes, sir.
It is, I also have deep roots in the great state of North Carolina. And so I would just like to say that it is great being here. I have a cousin who also served in the General Assembly and also served on the great Board of Regents at the UNC Chapel Hill. So it's great to be back at my other home.
Well, thank you for sharing. We're glad to hear it. And I'll just tell you that UNC Chapel Hill is something close to many of our hearts.
Yes, indeed. Yes, indeed.
All right.
Thank you so much.
See everybody tomorrow.
All right.
Thank you. Thank you.